Similar petition, my lord, pertaining to the public works department. Now, what has happened, my lord, nowadays, the PWD has introduced the new system where along with the bid, my lord, a site inspection report duly countersigned by the executive engineer is required to be given. So, my lord, I have applied, they are not giving it to me. Otherwise, I am eligible. Idea is to restrict competition. 28 is the last date, my lord. I applied on 14, then I did on 16, then on 20. Diploma.
With due permission of the other side, I would like to mention item number 35 of admission. Madam is undergoing treatment of eye operation. That is why the matter may kindly be listed after, if possible, after 15th of August.
Let us stay.
Lowest.
It has been submitted by the learned counsel for a petitioner that some accommodation is required in view of the fact that Dr. R.C. Borpatra Guhai is suffering from eye ailment. This matter on 1st of September 2025.
17th September.
1st of September.
May please wait for this motion letter on Monday.
Why?
Urgency is there also.
What?
There is illegal construction of medical substance is going on outside the area. It is 5 minutes.
My lord, I beg to mention item number 34 and for the respondent number 2 and 3 on behalf of Nishan Das. My lord, we have filed our affidavit in opposition today morning, so it may come on record. I pray for listing of the matter on Tuesday if possible. My lord.
Why?
My lord, the Nishan Das, the council is out of station and requested for Tuesday.
Let us stay.
No, man.
Have you taken the
Consent.
on consent?
Yes.
What is the matter about?
My lord, petitioner's matter is that the eligibility certificate for the expansion of their industrial unit has been rejected by the respondent corporation. We are for the corporation.
It has been submitted that an affidavit in opposition has been filed on behalf of the respondent number 2 and 3 today. To list this matter on 8th of September 2025. In the meantime, the petitioner would be at liberty to file the reply. 8th of September.
May I please, Lord. Also, I beg to mention item 21. I may be allowed to withdraw the petition.
Your name?
S.H. Ram.
Mr. S.H. Rahman, the learned counsel appearing on behalf of the petitioner. And who is there? Mr. B. Chaudhary appears on behalf of the APDC. Mr. S. The learned counsel for the petitioner seeks for an accommodation. Submits that he has instructions to withdraw the instant writ petition. Taking into account the above, the writ petition stands closed on withdrawal.
All right, sir.
Lordship, I get to mention item number 3, my lord. My lord, matter may be only for passer for only for day, my lord.
Why?
My lord, my senior is annual, my lord.
You do it. You do it. Motion matter. Easy.
Yes, my lord.
Next.
And please, Lordship, I beg to mention for listing of a writ petition. Lordship, matter may be listed on Wednesday, Lordship.
Okay.
Item number 47, the petitioner has filed an affidavit regarding the survey. It may be called for.
Okay.
Mr. Lordship, I beg permission to this petition for listing for admission on 1st August as similar matters are listed on this same day.
Item 1. May I please, the contempt application, madam. The direction at page 11, my lord. Is a pass under.
How is this possible?
instruction, my lord.
to withdraw.
So, my lord, the one, my lord, company name, my lord, Emron, who has also participated in the same tender process, connected tender process. They have cleared the bill, my lord. I
So
will
have
place
you
my-
mentioned about that?
No, my lord, I will place.
Have you
the-
mentioned about that other persons who are there, whose names are there in Tamsir Ali, as per Tamsir Ali has already got the benefit, but I have not been granted?
Place documents on the, my lord. like,
No,
I get-
nothing doing. The order cannot be complied with. If it has to go as per Tamsir Ali, Tamsir Ali. The Tamsir Ali says that, okay, it will be put in the list. And as per the list, you will get it whenever they have the money or whatever may be, as per seriality. So it cannot happen like this. Order is not,
place, my lord,
I am not going to
documents,
issue
my lord,
this type of notices. There's no contempt.
place-
When an order is not compliable, then how is it? Just tell me one thing. On consideration of the submissions made by the council for the parties and respondents have taken a stand that they will verify the supply order, supply made and liability amount payable to the petitioner in Tamsir Ali. The respondent shall accordingly do the same within a period of 3 months from the date of receipt of the. The payment of the admitted will be made 1 month thereafter. Now, if Tamsir Ali is to be applied, how can there be a direction to pay? Isn't it goes against the full bench judgment?
My lord, I sought for the list, my lord, where to.
You got a wrong
payments were
order.
made, my lord. The
Wrong
next
order.
I'll get
Can't
it,
help. No case.
Get it, documents, my lord.
File additional affidavit. The counsel appearing on behalf of the petitioner submits that he would like to file an additional affidavit, list the matter again on such
I'm the PO.
after 1 week, date of the deed. Last Friday.
Public.
After 1 week will reply Yadibo. Put it on for 8th of September, August.
May please. There is an order on 23rd, Lordship. And assailing that order, Lordship, I have already prepared on writ appeal, Lordship, which is under consideration, Lordship. Otherwise, the matter is infructuous, Lordship.
Otherwise, the matter has become infructuous.
Yes, Lordship.
Really?
Lordship, the fact is that challenging one approval, Lordship, I approach this honorable court, my learned friend on the motion, the Lordship itself submitted before the court that the petitioner is Lordship fact. Accordingly, not the fraud, Lordship. He submitted, my learned friend submitted that the principal was not appointed by the NEST, NEST. Lordship, accordingly, the honorable court directed the CBI to CID, Lordship, to make a preliminary inquiry, Lordship. And based on that, Lordship, order dated 23rd has been passed, Lordship. And I have challenged that, Lordship, and CID has already registered a case, Lordship. I am under protection, Lordship.
So what do I do? Take away the protection?
No, Lordship. I file one anticipatory bill application, Lordship.
What do you want now?
Lordship,
Withdraw.
case may be withdrawn, Lordship. I will challenge the, I have also prepared one application, Lordship.
What is your case? Let us see.
Lordship, the case is that, Lordship. Challenging, Lordship, the annexure I, Lordship, space 25.
So you are challenging some administrative approval.
Lordship,
Now, first of all, to challenge it, you have filed it as
principal, Lordship,
the principal.
Lordship.
Now, this principal, you are not approved.
No, Lordship, the fact is that whatever submission was made by my learned friend
Hmm.
is not also correct, Lordship.
Hmm.
My learned friend submitted before this court that the principal is fraud, as he was not appointed by the NEST, Lordship.
So the filing of the case by an institution
Lordship,
through a principal who is fake
Lordship,
does not arise.
Lordship. But
That is his case.
My case is that, my lord, this principal, this petitioner, my lord, has no locus to file
The
this.
petitioner has the locus, but on behalf of the petitioner, the principal filing has no locus.
My lord, even the school, even, my lord, that is why investigation by this honorable court has given.
Hmm.
The thing is that, my lord, Government of India through Ministry of Tribal Affairs has sponsored money, land, everything to Assam government to build a school, my lord, in Dalbari. Through Tribal Affairs Department, Assam. Through PWD, we started construction, my lord. The school belongs to central government, Tribal Affairs, Union of India. In between, my lord, on the verge of when the building was almost complete, my lord, what happened? This principal and two others, they encroached upon that, my lord, and they have taken over that entire building. And now, my lord, they are trying to harp upon that this belongs to them. They don't have any document to show that they have, this principal was appointed by Tribal Affairs. Nothing. That is why, my lord, this honorable court has taken the cognizance, my lord, and so much, my lord,
We should be more serious in
Lordship,
this matter.
Lordship,
was, my lord, this school belongs to the tribal children's, my lord, and now,
And where, in which case he has got a protection?
my lord,
in
this case.
This case.
Lordship. Lordship,
We remove this protection. You should be sent to jail.
Lordship,
Yes.
Lordship.
No, you will be sent to jail. No, no, no. No, nothing. No, nothing doing. You should be sent to jail. You are encroaching upon somebody else's property. Tell me on what basis you have a right to have a school in that place. No, no. Tell me.
I'm going to that. Lordship, the fact is that Ecolabbo Model Residential School was established by the Ministry of Tribal Affairs, Lordship, in the year 1997, 1998, Lordship, in tribal areas, Lordship, in tribal areas for the tribal student and student of BPL category, Lordship. There was, BTAD was not included in under 6th schedule, Lordship, till on that particular period of time. BTAD was included. While BTAD was included, Lordship, a revised guideline was issued by the Ministry of Tribal Affairs in the year 2010, Lordship.
No, no. How does this
Yes.
petitioner,
Yes,
Ekalabya Model Residential School, Dholabari,
yes.
have any right over that school? Show me that.
Lordship.
Where? Where is the document?
Lordship, I'm going to that, Lordship.
Please come to
Lordship,
that.
kindly have a look at my additional affidavit filed in the read of Lordship. That there I have critical legal status, Lordship.
Where?
The Lordship, this is the yes, this is pending before the division bench, Lordship. It is pending before the division bench, Lordship. Lordship. The principal was, sir, Lordship. Before going to that, Lordship,
Oh, you are challenging some order passed out here.
yes, Lordship, in the division bench, Lordship.
What order you have challenged?
Lordship, order.
Filing of, my lord,
23rd,
criminal case, my lord.
23rd, Lordship, no, Lordship, 23rd. I have 23rd 6, Lordship,
13-6.
13-6, Lordship.
13-6, my lord.
13 is not, thereafter there are another order that is 23rd 6, Lordship.
By that order, criminal investigation was, my lord, ordered.
Already registered, Lordship, criminal case, Lordship. And I have appeared. And statement have been recorded, Lordship. And the principal is authorized by the deputy commissioner, Lordship.
My lord, deputy commissioner has no business. No business, my lord.
Lordship, the DLLC is headed by deputy commissioner.
My lord,
District level, DMRS,
No, no, no. The petitioner is okay.
Lordship.
Petitioner is okay, as it seems from the order passed on 13-6. But a person representing the petitioner is fake.
principal.
So that is what I said. You are saying if the petitioner is also fake. No.
That bill, and the bigger question is, my lord, yes.
The
got it, my lord.
petitioner
That school.
is not fake. Who is fake on behalf of the petitioner? The principal is fake.
Yes.
However, has not made the Borolan model in the party. Like to make criminal responsibility to the principal.
My lord, এটা কাটি দিছো না মই দেখাই আছো তোমাক দেখাৰ পৰা তো নহব না
Next was established in the year, Lordship, 2019, Lordship.
before that
Before
before
that, I was-
the tribal affairs, my lord, tribal affairs, let them show, my lord, that my lord, the very only simple thing is that let him show, my lord, this is a central government institution. Let him show a salary slip that he has received any salary till today. Forget his
No,
appointment,
sir.
my lord. My lord, this is central government institution, my lord. Pure,
Till
100%,
date, Lordship,
like
no
in
fund have
Vidalaya.
been- no fund have been released by the central government, Lordship. It was running by the Lordship, the NGO Lordship, as per 2010 revised guideline, Lordship.
My lord, that it's a very, my lord, big scam. They are trying to, my lord, these few people is trying to take over, my lord, 100 property of the central government. My lord. That is the thing.
And the society has already handed over the school to the district level MRS, Lordship.
We don't recognize those things, my lord. These are society, they are creating by themselves.
If your Lordship kindly come to the page number 123 of the additional affidavit, Lordship. As per 2020 guideline, Lordship, district level MRS have been constituted and accordingly, Lordship, letter were issued to the President and Secretary of the NGO, Lordship. And the responsibility was given to the additional Deputy Commissioner, page 124.
Deputy Commissioner to the CID here said that, my lord, the Deputy Commissioner Baksar has also served a notice seeking for the above two answers, but he could not produce any supporting documents.
Then Lordship 125.
Okay, so a case has been registered against.
Registered, Lordship. Case registered, Lordship.
Now
And
what has happened in the
Lordship,
division bench?
before the investigating
You
authority.
understood, it's
Division-
okay, but what has happened in the
Lordship,
division bench?
Lordship, liberty was granted in the writ appeal, Lordship. I had not annexed these documents.
I'm asking you what happened in the writ appeal?
Lordship.
The
Allow-
the
allow
very
me-
first day, my lord, Honorable Division Bench did not say that we will not interfere in this.
No, Lordship.
Then they short time to file one
This
additional affidavit.
additional affidavit. It will be listed by Lordship.
Where's the additional affidavit?
Lordship,
It has not come here.
Lordship,
So what to do?
Lordship,
My lord will keep this pending, my lord.
Keep-
This
keep
has
this
got a
pending,
very
Lordship.
serious consequences, my lord,
Lordship,
of this school, my lord, this children's, my lord. So, my
Now, I
lord,
think we should monitor
yes, my
the
lord,
investigation.
Lordship, Lordship,
that is my prayer, my lord.
Lordship,
Monitor the investigation.
Lordship.
And if it has not been done,
Lordship.
have you been arrested or not?
Lordship, no, Lordship.
The case of 420,
My lord, for one,
406,
my lord, for
everything comes in.
for almost 20 days, the police, my lord, team visited like anything, but it was in
Oh.
BTR, could not find. In the meantime, during vacation bench, they got a interim protection, my lord.
Where?
On 10, Lordship.
On
In
10.
which case?
In
In that CID, my lord.
CIDPS case number 11 oblique, Lordship, 2025, Lordship.
WBC.
Not Lordship, that is Lordship, CIDPS. Person to court order, Lordship,
Where did you get the benefit?
Lordship, in AB application, Lordship.
AB. Where's that AB?
AB,
AB is today also, it is, I think, my lord, fixed.
Let us get the AB here
Lordship.
and vacate that order. And after vacating that order, ask the personal appearance of that petitioner before this court.
Lordship,
And also ask the officer in charge to come. Arrest him. What do you say?
Lordship, today, Lordship, may adjourn, Lordship, at least till the next posting of the matter in the division bench, Lordship, at least, Lordship. There is no problem, Lordship.
Heard Mr. H. Talukdar, the learned counsel appearing on behalf of the petitioner, and Mr. R. Dhod, the learned additional senior government advocate, who appears on behalf of the Tribal Affairs Department of the Government of Assam. Is Union of India a party out here? Mr. So-and-so appears on behalf of the Union of India. Full stop. Full stop. Okay. I heard Mr. So-and-so, the learned counsel we issue notice making it returnable on 22nd of August 2025. Mr. So-and-so accepts notice on behalf of the respondent number 1, 2. You. Union of India, who is there? Then are you accepting notice for 1 or not? 1 and whom? 2? 2. Obviously, Mr. Dhar doesn't go to Delhi. 2. 1 and 2. Mr. Dhar, R. Dhar appears and accepts notice on behalf of the respondent number 3, 4, 5, 5.
5 is my lord K. Sharma.
Huh?
Anshuman Sharma. My lord.
3, 4, 5.
He is there.
3, 4. Also you. Okay, Mr. So-and-so accepts notice on behalf of respondent number 5. And who is this PWD business? Ms. Arbora appears on behalf of the respondent number 6, 7, 8, 9. And where's the government? You take for the 10 and 11 also. And I Ardhar Koribo 10 and 11 also. Pustap. All the respondents are duly represented. Pustap. Extra copies of the writ petition be served upon the councils during the course of the day. Pustap. The petitioner herein has filed the instant writ petition seeking a direction that the administrative approval so granted be modified. Full stop. It is seen from the records that there are various orders being passed by the coordinate bench of this court to the effect questioning the local standard, questioning the representation of the person who has filed the writ petition on behalf of the petitioner. Full stop. It is further seen that there are certain reports submitted by the Superintendent of Police CID, wherein it has been mentioned that the appointment of the petitioner, appointment of that Sri Angelas Baxla, who has represented himself as the principal of the petitioner, has not been appointed, has not been approved or appointed to run the said institution. The record further reveals that this court have taken a serious note that a school is being run by Sri Engles Baksa without any authority, and have also directed registration of a case against the said Sri Anglas Baxla. It has been also informed to this court by Mr. Ardhar, the learned counsel, appearing on behalf of some of the respondents, that pursuant to the directions, what case number?
CID PS case number 11 of 25.
CID PS case number so and so 11 of 2025 have been registered.
25/6/25.
Huh?
25/06/25.
On
25/06/25.
25. Full stop. So, taking into account the above, this court would direct the respondent authorities to file their affidavits. And then full stop. This court further takes note of that there are various documents placed before this court by the respondent authorities. Full stop. It would be in the interest of the justice that the said documents be brought on record by way of affidavit. Full stop. The learned counsel, appearing on behalf of the respondent, submits that they would be duly filing the affidavit in that regard. Full stop. The maintainability of the writ petition is kept open. Full stop.
But if in the meantime, I also file one additional affidavit, Lordship, bringing the documents under record, Lordship.
You have filed?
Not file, it is filed in the readable lordship.
So go to the division bench and tell him. Yes, what is this? No. What is the prayer? NRC. Your name should be inserted in the NRC. Hello? Who is causing the problem? Huh? Issue notice returnable on 8th of September 2025. So and so accepts notice on behalf of the respondent number 1. Who appears? NRC, no counsel. Pusto. None appears on behalf of the respondent number 2. Ms. Udas, the additional senior government advocate, represents the respondent number 3. Pusto. It has been informed to this court that Mr. J. Pang is the standing counsel of the respondent number 2. Full stop. Taking into account the above, comma. Full stop. This court directs the petitioner to serve extra copies of the writ petition upon Mr. So-and-so and so-and-so. Ms. So-and-so, who represents the respondent number 1 and 3. As regards the respondent number 2, comma, this court directs the petition counsel for the petitioner to serve a copy of the writ petition upon Mr. J. Pang. Full stop. The case of the grievance of the petitioner herein is that the petitioner name have been excluded from the NRC, and in spite of various representations being submitted, comma, the respondent authorities have not taken due consideration of the same. It has been submitted by the learned counsel appearing on behalf of the petitioner that all other family members of the petitioner have already been included in the NRC, but strangely, the name of the petitioner was dropped. Taking into account the above, the learned counsel appearing on behalf of the account, taking into account the above, the respondents are directed to bring on record their stand by filing their affidavit on or before the next date. What is this? Fishery has not been settled with the petitioner till date. P. Sharma, why?
Process lordship. It is department case. It is in the approval has to be taken. It is on the pipeline lordship.
Oh, it is in the pipeline.
It is, because it is sent.
No, you have not been rejected. What is this?
Sir, I am apprehending.
Once your apprehension is for what? That they are not going to give you. If they don't give you, you are always at liberty to come before this court. What is this apprehension business? No, there is no, you just can't put a skeleton on the head of somebody and then the process your the tender process. Nothing doing. This is not a case. On apprehension, the moment you get a cause of you don't have a, the cause of action has not happened.
Tender was open on 4/7. 4/4 of July.
Last year. Oh, this year, my goodness. We will give it.
The last occasion.
And you filed the writ petition when?
4th July, DC, Deputy Commissioner has opened it. They have forwarded to us, Lordship. It will take some time. It's only 10, 15 days.
14/7 you filed it. You want it the next day.
Because, my lord,
We dismiss
the
it.
last-
No liberty also.
on the last occasion.
Heard Mr. N.K. Koilkar, no,
And this is
nothing
the last
doing.
order, madam.
No, nothing doing.
Last
Heard
order.
Mr. N.K. Koilkar, the learned counsel appearing on behalf of the petitioner. Mr. P. Sharma appears on behalf of the respondent numbers 1, 2, 4, 5, You are making somebody else a party also. 4 or 5. To stop Miss Yuda, the learned additional senior government advocate appears on behalf of the respondent number 3. To stop. The petitioner herein has approached this court on an apprehension that the petitioner would not be granted the settlement in respect to Sengazan Minmohol on the ground that the petitioner, though is eligible and technically and is the highest bidder. You are the highest bidder. Highest bidder. As per the comparative statement prepared by the Deputy Commissioner. Full stop. Mr. Peter Sharma, the learned counsel appearing on behalf of the respondent authority submits that in terms with the Fishery Rules 1953, the Deputy Commissioner, the District Commissioner has to take the concurrence approval,
Forwarded all the documents.
has to forward all the documents and also seek the approval,
Issue lots.
has to forward all the documents to the respondent's Fishery Department. And the Fishery Department thereupon would issue the said work order. It's a settlement. Full stop. The said aspect is presently under consideration of the Fishery Department. Full stop. Taking into account the above, the apprehension on the basis of which the petitioner has approached this court is unfounded, for which the instant writ petition stands closed. Full stop. This court, however, grants the liberty to the petitioner if so if the petitioner is otherwise aggrieved by the decision taken by the Fishery Department of the Government of Assam against the tender so submitted pertaining to
Sengazon.
against the tender Sengazan Minmohol. Put a bulletin on somebody. Yes, what is this, Mr. Das?
Page 41.
Huh?
Page 41, we kindly look.
Chief Judicial Magistrate, for what? The
My
government?
lord, there is, my lord, we were appointed in pursuance of advertisement in 10th of February 2025 for the post of peon. There were 5 posts which were vacant. Now select list was prepared on 8/4/2025 and we are appointed on 10/4/2025. We worked and we joined also on 11/4/2025. Now, my lord, what has happened, my lord? There is a writ petition which was filed by one of the candidates before this court, not for the post of peon, but they were promoted from grade 4 to grade 3. Now, page 41 will make it very clear, my lord. Kindly see page 41. That makes it very clear, my lord, what is the case. Kindly see that.
Tell me.
Now, after that, my lord, what happened that your lordship direction, that from filling the post immediately, and they have done it because it was not in person to merit come seniority. It should be seniority come merit. What your lordship has said.
I never
Yeah.
said that. I said that it is
It's not-
seniority come merit, but they applied the senior merit come
Merit cum
seniority.
That's what it said. So according all these 3 posts, out of 3, two post has been filled up. Following the judgment of this court, they said that it is seniority come merit. So they have filled up. Now the kindly see at page 51. I am agreed by 51. Kindly see.
What
this
is the
what-
name? Who is here?
I am the four petitioners. are
Vidisha
who have been-
Talukdar. Vidisha Talukdar was the person who's,
No, my lord, these are the post of peon, my lord. I am not so. questioning about
see,
it.
whereas 5 grade 4 peons, namely Vidisha Talukdar, Chandan Dotto and so,
Yes.
were appointed by my predecessor against the vacancy that arose due to the said promotion. That is
This
3
is
posts
RC.
along with 2 other existing vacancies.
Yes.
So meaning thereby, when there was a promotion being made by applying the merit cum seniority, although the seniority cum merit, there is a vacancy which has happened in that cadre.
Right.
So these persons concerned were duly appointed. Now against the vacant. So you are one of them.
Correct.
You are one of them. Whatever may be, you are
Correct,
one of
correct,
them.
Right,
So therefore, when that order has been set aside,
yes.
those respondent number 6, 7, and 8 in that
Yes,
earlier
again.
petition, they have been reverted back. Now, what is your case?
They are reverted back. Now they said once they are reverted back, 2 was already vacant. 2 were vacant, but they were filled up. Now, once it reverted back, the CGM was right, saying that what we'll do, we'll keep this in abeyance, your particular, but you are removed from joining the duties till it is resolved. Meaning thereby, once they are promoted, again this post will come up. Now, 51, kindly see what they does in Roman 1, at page 51.
Whereas the post are freshly recruited in
Yes.
the grade 4 by the appointment order due to vacancies arising for promotion to so and so. And Narayan Sharma to V. Amidation. Pursuant to the order dated so and so, the promotion of the grade beyond so and so has been cancelled. And although dated was denied on the basis of the select is stated 8.
Come and over to that. This is why now I am going to give notice to them. Ask. Now he said that fresh appointment. Your lordship never intended to say that my appointment should be cancelled. They said,
No. The question is, these people concerned
Yes.
were appointed against the vacancy which has arisen. Now these people have been reverted back. Now, where will you get your salary?
back. Said, as per direction. So now they have been promoted. Again, they have been promoted.
All
No.
these 6, 7, and 8 has now
Yes,
been
they've
promoted.
Two has been promoted. One is not been promoted only. Out of 3 who came. Now what he says, in persuasive order passed by this court, our appointment is cancelled. How this is not an observation. I very well, they have been reverted back to that post. No, absolutely. That is why what he said in page 41 that this has been kept in abeyance. You cannot join the duties till it is resolved. That means the promotion has to take place again. So there has to be some interview on the basis of seniority come merit. Fine, there is absolutely no
So
problem.
your case is once it is in abeyance,
Yes,
so your promotion, their post still remains.
that's
So
what.
therefore, the question of why there is a requirement of a fresh selection.
That's what.
That's your case.
Yes. And my lord, what he
The
says.
problem arose because in all matters pertaining to High Court earlier, with
Yes.
due respect, it has been mentioned that all these promotions shall be subject to outcome. But without taking into consideration that the moment there is what goes up,
Yes.
once these persons are promoted, there is a vacancy created. And if there is a vacancy created, that vacancy can't be kept for a
Correct,
long
that's what-
time. So these vacancies are to be filled up. So
Yes.
there should have been a stay,
Yes.
which stay was not granted. There should have been a stay, but the stay was not granted. But the fact that the manner in which they promoted there, under no circumstances could have been said to be seniority cum merit. It was just purely merit cum seniority.
Your lordship said, considering the petition, your lordship said that it cannot be in pursuance to the selection in rules. That is the Assam Chief Judicial basically established a municipal service rules. That your lordship applied that rule. That doesn't specify, that doesn't stipulate that the consideration of promotion should be on the basis of merit cum seniority, it is seniority cum merit.
while deciding by this chief judicial magistrate, he considered merit senior. That is why your lordship has
No,
said
no, that is okay. But the problem now arises is that those vacancies, the moment they are reverted back,
yes.
did you join prior to that?
Now,
Prior to my judgment, did they join?
yes, yes,
And did you get your salary?
yes, I was.
How
40
many?
days,
No,
40
you
days.
were appointed only on 10/4/2025.
Yes,
So my judgment came when?
your judge's lordship
Not
came
long that, my judgment came on
on
24/4.
24,000.
So your appointment came, I don't think you got a salary also.
Paisa?
How could you have got
No,
a salary?
yes, sir.
No,
40
obviously you
days.
couldn't have
No,
got
no,
a
40
salary.
days work, sir. 40 days we work.
No, you couldn't have been because the moment there is a question of reversion, my judgment came on 24/4.
My lord, my appointment was 10/4/2025.
That is what your
Yes.
appointment was on 10/4/2025. My
Yes.
judgment was of 24/4/2025.
Correct, 24.
So therefore,
And
as on that day, they were supposed to be reverted back.
No.
So in effect,
Can I just
the
clear it?
creation, there was no creation. The appointment may have been made, but these were all could not have remained for all
No.
because there was no post.
No, can I clear it, my lord?
Mm.
My appointment was on 10/4/2025.
Mm.
Your lordship judgment is 24/4/2025. I joined on 11/4/2025.
Understood.
11/4.
Understood, but the CGM establishment, the order which was passed initially categorically stated that the promotion so made shall be subject to the outcome of the writ petition, if I remember correctly. So therefore, whatever effect it is, everything gets nullified.
No, that was a dispute about it. What I said, the one side being reverted, those employee being reverted to the post, my post, rightly at page 41. The learned, the CGM rightly said, that what we do it, we keep you in abeyance until further orders. Then they will see consideration of promotion. Consequently, you are removed from the present duties with immediate effect. You will not join duties because they have to come back to your post. But your particular his appointment is.
So therefore, you were not appointed. Your selection was not on the basis of to a substantive post.
No, it was.
It couldn't have been when there is no substantive vacancy.
But see, advertisement. No, I'm
The
advertisement-
advertisement which was made,
on 10/4/2025.
whatever may be, the advertisement was made on in respect to vacancies which have arisen in view of the promotion.
Yes.
But the moment the promotion was set aside,
No, there only 3 posts. But 2 posts.
you are one of them.
Yes, I know, my lord.
There were against 5 posts.
My lord, my 5 posts. 10th of February 2025 advertisement. In the meantime, there was vacancy because
Anyway.
they have been promoted.
Anyway, we'll issue just a notice, nothing.
My lord, only what they want, my lord, the only problem here is that at page 52.
Because if I
press
stay now,
I'm not saying stay.
no,
No, no.
no, no, no.
Press
no,
appointment
I,
process.
there's, no, I cannot stay the process. What will happen to those filling up? You participate.
No, I participated, duly participated, I have.
No, you participate in the fresh proceedings
No,
also.
I.
Because
already-
otherwise, are you going to do the job free of cost?
No, I don't want, my lord. free
No,
of
no,
cost.
no, yeah, no. Somebody has to work. Till the disposal of the repetition, somebody has to work in the job, in the post,
We have been appointed.
without salary. No,
Yeah.
without salary, without claiming any rights. You could perform your duties.
Advertisement.
If you win the case, well.
My
No,
lord,
Mr. Das, if you win the case, well, very good.
In person, I think I could not have maybe your lordship understand about the case. Let me, 10th of February 2000 advertisement, at that time the post was vacant. The post was.
Yes, but those, one has to understand that vacancy which was there,
Yes.
it was subject to the outcome of the repetition.
That.
That
not-
you may not know. I'm not concerned. I'm not concerned, but you don't have a right on that. The appointment is illegal.
My appointment cannot be illegal. man. We did respect that.
When the appointment was made
Why-
without anything,
Again,
now we'll consider that.
my
We
lord,
consider, but there is no stay. You can participate if you want, but we'll keep it. If you don't get it, it will be subject to the outcome.
My lord, advertise, what is my fault, my lord, in this way?
Your
I
fault is,
participate.
your fault is,
in the
the,
party.
no, your.
I don't know what is the proceeding before the High Court, my lord. I have been appointed, I have been doing my job. Somebody is coming to the court, all right, that's so, okay, fine, my lord. 10th of February, advertisement, there was vacant post. Somebody else was subject to further outcome of the writ petition. They were reverted back, fine, my lord, there is no problem. But they are reverted back, again they have gone back. That doesn't mean when my advertisement become illegal, my lord, with great respect, my lord. They have been reverted back and they went and promoted, my lord. So my advertisement has become nullity, my lord. I have been duly selected.
It is not a nullity. That is why I am issuing notice.
That is what I'm saying.
You are
So,
getting a notice because of that. That is not a nullity.
No, that is what they said.
We will consider. We will consider. Let them go ahead with the fresh appointment proceedings if they want. Let them go ahead. And if they do so, then it will be subject to the outcome of the writ petition. And if you win this case, well and
Again,
well.
with the same problem, my lord.
No, there is no problem because
Yeah.
this is the initial post. You are in the grade 4.
I
So
know.
this is the initial post. So if you are in the initial post, there is no problem of reversion back. Now, if because the only problem which I am facing is when you were appointed there, appointed against a vacancy which was made subject to the outcome of the writ petition in the earlier one. So in that case, because you are not 1 year, you are 4.
Right.
Problem arises because of that. If it was 1, because there were 3 vacancies and 2 anticipated. There were 2 vacancies and 3 anticipated.
But when lordship as far, that will be subject to the outcome.
Because my order was only affecting 3 anticipated vacancies.
Your lordship's order has complied, and they have been promoted. They have been promoted. So this post, which has been kept, again, this is vacant, my lord.
But just tell me, tomorrow, if your writ petition is dismissed, what happens? If I stay it, you'll be working. It will be kept in abeyance. So these 3 posts will be vacant, or 3 or 4 posts will remain vacant. These 4 posts will remain vacant in that establishment.
No, now these 4 posts are still there because of promotion.
Will be kept, will be vacant in the establishment. So should this vacancy in this post remain for all this time?
That prima facie case. Prima facie, I am showing a case.
So the prima facie, you have a case,
So,
but the
saying-
balance of convenience is not in your favor.
Not
For stay,
saying submission.
we
with
need
great
all
respect.
3.
No, with great respect, my lord.
Yes.
No, with great respect, my lord. See, this post is vacant and it is not that I have got the job, not through an advertisement. I got to the job and your lordship's direction, as I understood, was that it will be subject to the outcome of the final outcome of the writ petition. Now, what has happened, my lord? Final outcome of writ petition is that they have been reverted back and again they have been promoted. So this post becomes vacant. So the order at page 41, which you have asked,
How do you say that these people have been promoted?
this is I have told. This
No, don't say I have been told. I am not going to go on the basis of I have been told.
saying that this
No,
post
that
been
has
filled up.
nothing to do. You don't make that submission.
No, with responsibility I am making.
No, you cannot.
With-
How can you make a submission? You are a senior counsel. How can you make that submission? You are only on the based on instructions. Then the instruction is somebody else. And that is not stated. Have you stated that these people have been
Yes.
promoted?
There are. Yes. Page 18, my lord. Page 18.
Yes.
There are 19, my lord. The petitioner, there are sufficient posts vacant on the SL 3 posts again with the petition further to the knowledge of 3 posts of the office and again with the petitioner early appointed vacant and no fresh appointment process initial with regard to the office and the officer. Hence, there is no impediment to allow the petitioner join back in the service of office and the established, allow them to continue the service and entry measure.
No. Yeah, you don't say that those people have been transferred, promoted because those people couldn't have been transferred because they were junior. See, those 6, 7, and 8 in the earlier writ petition, I interfered because of the fact that these people were junior, but on merit, these people were given.
Right, that's right, that's your. logic,
Now
right.
they may have had a selection process, and those 3 posts have been filled up. Those 3 posts by way of promotion has been filled up by which other, by the, maybe by the petitioners in the earlier round of litigation, they may have been filled up. So these people have not been, now there might have become a vacancy. The vacancy has again a reason, but those vacancy which you, at the time of your appointment, which is a reason, because the moment the problem arises, if I allow you to work today, do I allow you to work that tomorrow if your writ petition is dismissed? Then problem arises there. I can't allow you to work. What you are asking in paragraph number 19, it is a very difficult thing. Tomorrow if your writ petition is dismissed, are you going to return back all the money? I'm telling you. It will have a more cascading effect upon your counsel, upon your petitioners.
No, I got your point, your lordship's, I understand.
So the best way is issuing a notice, let it remain out there, no stay, nothing doing there. You, what do you call, file your affidavit. That is the only way out. Whether the question is, whether the only question which is remains out here, that they were appointed against an anticipated vacancy. Now, once that vacancy, these anticipated vacancy against that they were appointed, which became clear in view of the promotion, but again, in view of the interference, these promotion has again gone, so these posts were filled up, and these posts again have become an anticipated vacancy because of the promotion. Because you can always take it, because when there are 3 posts which are vacant in the higher cadre, and the feeder category is there to be promoted. So again, these also posts becomes a feeder anticipated vacancies because you are taking up a step for the purpose of promotion. Isn't it? Just for example, we are concerned with the JA. These are JA?
It's beyond
Grade 4.
Grade
So the promotion was to the JA, most probably. Judicial assistant. Huh? Judicial assistant. So the moment these office peons were promoted initially on the basis of merit cum seniority or whatever may be, it was kept. These 3 posts were against anticipated vacancies. You have initiated that. But the moment these anticipated vacancies were lost in view of the filling up of the post, again you have taken, and in the meantime the appointment has been made. The appointment was on 10/4. And my order was on 24/4. So the vacancy which was arisen in respect to those posts have lost. There's no vacancy. So obviously, they could not remain in service. There cannot be 2 persons because there's no post. So they have to be kept in abeyance, which the CJM has done. His only question is, should the CGM now fill it on the basis of these selection which have been done earlier, or that selection becomes non-est as per you? If it becomes non-est, then the question of fresh promotion will come in, fresh selection. And if it is, can be kept in abeyance till again the process starts. Because again you have an anticipated vacancy. Because there are 3 posts in J still vacant. Because we consider to be an anticipated vacancy, meaning that the posts are still there. The posts are still filled up, but it is going to get, the promotion will happen. There's a likelihood of a promotion. Because if you see those rules, more particularly the rule says about anticipated vacancy also, if I'm not wrong, the rule 12 or something, I will look at it. Heard Mr. Issue notice making it how much time? I could matter short. Issue notice making it returnable on 21st of August 2025. Mr. T.J. Mohanto. appears on behalf of the respondents, the learned standing counsel, as well as the senior counsel, appears on behalf of the respondent numbers 1, 2, and 3, and the learned counsel assisting Mr. T.J. Mohanto accepts notice, means name to the depot, accepts notice on behalf of the respondent numbers 1, 2, and 3. Extra copies of the petition be served upon them during the course of the day. First of, the case of the petitioners herein is that on 10/2/2025, an advertisement was issued by the Office of the Chief Judicial Magistrate Sibsagar for filling up 5 posts. Full stop. The petitioners, how many petitioners are? Four are here, no? The petitioners participated in the said advertisement and were selected. Full stop. It is pertinent to take note of that the advertisement which was issued on 10/2/2025 were in respect of 5 posts, out of which 3 posts were vacant posts and 2 posts were 3 posts were on account of vacancies which arose due to promotion, and 2 posts were already existing vacancies. First, it is pertinent to take note of that the 3 posts which arose out of promotion, the vacancy in respect to 3 posts which arose out of promotion on account of the promotion, the promotional order was set aside by this court in WPC number 5851/2024. And therefore, those persons who were promoted were reverted back to their original posts. Post. Under such circumstances, the Chief Judicial Magistrate Sibsagar passed an order on 25/2025, whereby the promotion made to the 5 persons by the order dated 10/4/2025, which included the 4 petitioners herein, was kept in abeyance. First, the grievance of the petitioners herein is that the petitioners have been duly selected after a due selection proceedings. And as such, the grievance of the petitioner herein is that in the meantime, pursuant to the judgment and order passed by this court on 24/4/2025 in WPC number 5851/2024, the Office of the Chief Judicial Magistrate Magistrate Sibsagar have already promoted officers, have promoted the peons to the post of judicial assistants. And thereby, the post, the vacancy, the vacant post against which the petitioners were appointed have again arisen. It is the case of the petitioners that the petitioners, therefore, the case of the petitioners, that the said order by which 25/2000, the order by which order dated 25/2025, by which the appointment of the petitioners was kept in abeyance, ought to have been modified, and the petitioners should have been allowed to join the posts. Rather, the Chief Judicial Magistrate Sagar had passed an order on 25/6/2025 intending to go for fresh selection against all the 5 posts. First, this court have duly, Mr. Dida, the learned senior counsel, submits that the order dated 25/6/2025 be stayed and there should be a direction passed that the petitioners be allowed to work pending disposal of the writ petition. First, this court is of the opinion that passing the interim order as sought for would amount to allowing the writ petition in the interim, allowing the writ petition would amount to passing the final orders in the instant writ proceedings as an interim measure, which would go against the well-settled principles of law. Under such circumstances, this court is, however, not inclined to stay the impugn order dated 25/6/2025, as well as issue any directions allowing the petitioner to perform their duties on the basis of the order of appointment dated 10/4/2025. First, this court, on the other hand, would directs the respondents herein to file their affidavit by 18th of August 2025, so that an attempt can be made to dispose of the writ petition on 21st.
Advance copy so that we can give a reply. We can give an advance copy to us. So that we can
18th is advance copy.
advance to us,
The 18th is advance. They cannot file without giving you a copy.
go there.
Before filing only, they have to give you a copy. Otherwise, the registry won't accept.
This is in respect of a fishery. The petitioner, my lord, has filed application before the authorities for remission. On the ground that because of various factors, my lord, primarily because of flood, my lord.
Flood in fishery.
Yes, my lord.
Okay.
Saplings have swum away, and my lord, the entire fishery is, my lord, under water descent, not, my lord, operational. My prayer at this stage will be, my lord, for issuing issuance of notice, because, my lord, in view of my applications, there have been 2 inquiries conducted, and those inquiry reports.
Are you still running the fishery? Okay.
Only notice will be issued.
Now what do you want? Only notice. Issue notice making it returnable on 19th September 2025. What a no.
7 years. Till 2013, they will be with us.
Let's just have it after October.
Yes, Lord.
Huh?
After October will be better.
Let him also be more freshened up. No, let's have it on 19th of September. Issue notice making it returnable on 19th of September 2025. Mr. P. Sharma appears and accepts notice on behalf of the respondent numbers 1 to 6. Ms. Yudas accepts notice on behalf of the respondent number 7. 3 and 7.
Three and
Majority to
3 and 7. Yes.
3 and 7. 5 also. 3, 5 and 7. Chalo. Extra copies of the petition be furnished to them by tomorrow, by Monday date to deliver. The petitioner, the case of the petitioner herein is that the petitioner where's your settlement?
29.
Then Assamese.
No, 28. Yes. 28 in English.
That is the type to be 28, 29 is the
Yeah. It's the case of the petitioner herein that the petitioner was settled with the Samuguri Min Mahal under Nagaon district. For a period from 2022-23 to 2028-29, that is up till 31/3/2029. Full stop. On account of late handing over of the possession, which the petitioner states to be 216 days, as well as on account of floods, the petitioner has suffered, and as such, the petitioner have sought for waiver of the kissed money. First, the said aspect being which was duly intimated to the concerned respondent authorities and represented thereupon for waiver, seeking waiver, have not been redressed, for which the petitioner is before the court. First, the respondents are directed to bring on record their stand by filing the affidavit by 11th of September 2025. The petitioner would then be at liberty to file any reply if so advised.
File seeking a direction from your lordship to release my earnest money, your lordship.
Earnest money.
Earnest money and other security deposits, your lordship.
Why? Is it not contract money? Earnest money, why you are not paying?
Your lordship, completion
Well,
certificate.
That's the instruction manual, why it is holding up on it. It seems they have cleared up all their dues. Other bills and everything they have paid. Only this, why they are holding up, maybe there are some reasons, I don't know. Madam.
Next week. Only that simple thing. And it is not your money,
No money.
his
They
money.
did.
So his money, he should get it. Or if you don't, they want to have the money, pay interest as if you are taking a loan. As if you are giving like a credit card interest, 2% per month.
That's why I'm not seeking.
You have a lot of money.
I'm not seeking for notice, madam. I take instruction.
No. Notice is a must in my court. Issue notice making it returnable on 1st of August 2025. Mr. Ardhar accepts notice on behalf of the respondent number 1, 3, 4, 5, and Mr. Arbor Pujari accepts notice on behalf of the respondent number 2. Extra copies of the petition be served upon them during the course of the day. The petitioner hearing is aggrieved by the action on the part of the respondent authorities in not releasing the performance security, that is the earnest money amounting to rupees 4,41,500, as well as the security deposit and performance security deposit totaling to rupees 7,94,532. In spite of the fact that a petitioner had completed the work to the due satisfaction of the respondent authorities. Full stop. Mr. Ardhor, who appears on behalf of the PWD, shall obtain instructions and place it positively on the next date as to why the earnest money as well as the performance the earnest money the earnest money the earnest the performance security the security deposit as well as the performance security deposit referred to above herein above have not been returned to the petitioner. First list according.
Can it vote?
No, next week. Huh? You just call up. Should you have any problem with it and take it up today at 2? Just a call. Huh. Yes, Mr. Zain. Huh?
Non-payment of the requisition.
Issue notice making it returnable on 19th of September 2025. Steps be taken. Ms. Yudas, the learned senior government, additional senior government advocate, appears on behalf of all the respondents. On behalf of all the respondents, except respondent number 2, for whom Mr. Arbor Buzari accepts notice. Extra copies of the writ petitions be served upon them by Monday date to delivery. The case of the petitioner herein is that the petitioner gave on hire his vehicle bearing number AS01FR 9005 to the respondent authorities for the period from 28/2/2024 to 31/3/2025 and submitted a bill of amount of rupees 8,64,814. It is the case of the petitioner that the said bill upon being submitted was not paid in spite of being duly represented. It is under such circumstances the petitioner is approached this court. It issue notice to October 17 kori dibo te. Iman juldi na lage. October 17, because here this is too early. For the government, they have to get at least 2 years cushion. Yes, what is this? NIT.
Pursuant to the NIT issued by the concerned Gao Panchayat, my lord, we participated, submitted our
Hey.
tender.
No, how could you have funding to it? Yes.
My lord, we have submitted our tender and my lord, ultimately, my lord, the petitioner of the lawsuit was selected. And then my lord, settlement order has been issued in my favor, my lord. And thereafter, my lord, I have asked to deposit the entire money. I have deposited the entire money. I have took over the position of the market. I started running. And thereafter, my lord, the private respondent filed a complaint, my lord, to the additional secretary saying that there was some anomaly in the lottery, my lord, and therefore.
Lottery, what lottery?
Lottery, my lord, the petitioner and the private respondent were having the equal amount, highest amount. And thereafter, the system is this, my lord, that in that case, my lord, the lottery is to be rotated in places of the officials and both parties.
And accordingly, my lord, they have arranged, particular date is given, time is given, both parties were appeared along with their persons, my lord. Publics were also there, and the officials, my lord, they have drawn a lottery, my lord. And in the lottery, my lord, I have been selected. And then, my lord, upon my letter.
Then he gave a complaint.
And then, my lord, the settlement order has been issued.
Where's the complaint?
Complaint is not there, my lord,
Then how do you know?
but
Where's the impugned order?
but that is reflected that my lord will find in the order itself, my lord. That my lord will file page 25. Is this, my lord, if anything is there, my lord, let them continue. But in the meantime, my lord, since I have taken over position, I have paid the entire amount, I am starting running, my lord, I am be allowed to run. And let them take a decision, my lord. Until then, my lord, that's my lord, humble. Where we were lost.
No, where it has been mentioned that you have been stayed. Page 25
State-
does not say that it is stayed.
State, my lord, 27, page 27, next week. That was issued by the Panchayat, my lord. Pursuant to this order, my lord, it was communicated to the Panchayat, and Panchayat had issued the state order. That is last page, my lord.
No, therefore, as directed, the settlement of the Hat Bazaar has been kept on hold until further orders. Mr. Kaur, what is this? There is no direction to that effect.
Lordship, the case number 25, Your Lordship.
Where is the direction?
Your Lordship, the last but one paragraph, Your Lordship. In view of the above, you are requested to submit a detailed report with proper assessment from your end regarding the conduct of the lottery held on 26/6/2025.
Oh, the decision of the lottery held on so and so may
That
be
is
kept
kept
in
in
abeyance.
So government has the power. Your Lordship.
I'm not disputing the same. What I'm saying is this, my lord. Since settlement order has been made, my lord, I have paid the entire
Now,
amount.
what happens if you are settling this Saturday market?
Yes.
You get some revenue.
Yes.
Now, if it is stayed, is it in the interest of the state? It's okay.
Yes.
One can very well have it. Have a decision within 10 days, 30 days, or within 20 or 30 days, you have the decision.
Yes.
But till the decision, why are you not allowing? Because he will be, then you are losing on the money.
Yes,
One has to
in both
think
ways.
about the state also.
Yes.
In both sides, you are going to get the money, but if you are holding that he is not, means he cannot collect, he will not be paying you. Or has he paid? Have you paid earlier? You have not paid.
I have paid the entire amount. Now,
So,
the end
so
of
you will
whole
be
year.
asking for remission.
Lordship, the, as per my telephone instruction, Your Lordship, the concerned chief executive officer has already forwarded the report. to the government.
Report has been submitted.
Report has been submitted, awaited final decision, Your Lordship. One lead time may be given, Your Lordship.
We do one thing.
Yes.
We issue a short notice by 1st of August.
Yes.
Take a decision by then.
Yes, yes,
And if the decision is being taken against him,
yes.
good. If it is in favor of him, good.
Yes.
Always. Matter becomes infectious.
It will be.
So you have to take, as you submit,
Yes.
that the report has been submitted,
Yes, sir.
and you are going to take a decision by first.
Yes, yes.
Okay. I think this is the best way out.
Yes.
Issue notice returnable on 1st of August 2025. steps with Mr. Kekwar, the learned standing council of the Panchayat and Rural Development accepts notice on behalf of respondent 1, 2, 3, 4, 5,
6.
5, not 6, nah?
Or 6 also.
6 also, nah? 6.
6,
First of-
yes.
This court for the present would not like to issue notice upon the respondent number 7. First, the case of the petitioner herein is that pursuant to a tender process initiated in respect to tender process initiated by the secretary Tumuki Gaon Panchayat in respect to Tumuki Saturday weekly market as there was as the bid of the petitioner as well as the respondent number 7 was the same, comma, a lottery process was by way of a lottery, comma, the petitioner was declared to be the successful bidder. And in that regard, a settlement order was passed on 27/6/2025. Full stop. The record further reveals that based upon a complaint made by the respondent number 5, comma, the 7, the additional secretary to the government of Assam Panchayat and Rural Development Department have directed the chief executive officers, Honipur Jila Parishad, to conduct a inquiry and submit a report as regards the transparency in the lottery process. There is also a further direction that till the decision of the lottery held on 26/6/2025, till the such report being submitted, the decision of the lottery held on 26/6/2025 may be kept in abeyance. It is further seen that pursuant thereto, on 18/7/2025, the secretary Tumuku Gram Panchayat had issued a communication directing the petitioner not to collect the weekly tax. And it is under such circumstances the petitioner is before this court. Mr. Kekwar, the learned counsel appearing on behalf of the respondent numbers 1 to 6 submits that as per his instruction, the report have already been submitted to the additional secretary to the government of Assam Panchayat and Rural Development Department, isn't it? And a decision would be taken at the earliest. Full stop. Taking into account the above, comma, this court has fixed the matter on 1/8/2025. And Mr. Kekwar, the learned counsel, shall apprise as to whether any decision has been taken.
And in the meantime, my lord, I will be allowed to run.
No.
Since I have already completed the entire
Saturday is only tomorrow. By the time the order gets signed, you would not be. So next Saturday, we are having on Friday. So he is coming up with that. I'm not mentioned that to pastor, yeah, but I've asked you that to submit it, meaning thereby you will understand what is required.
Yes. Sometimes what happened, the other side appears and prefer, my lord, time for filing affidavit and all, my lord. So therefore, my lord, till final decision is taken, my lord, may I allow to since. my
Mr.
lord,
M.H.
the money-
Chaudhary, I am fixing the matter on 1st of August, next Friday. I'm asking him to take the decision on then, because the moment they take a decision against you, you will be challenging it. And if it is in your favor, your petition becomes infructuous. So in either way, the matter gets finished. Non-payment,
Lordship.
how much?
Page 17. Lordship. Page 17, the liability statement. The admitted amount part payment.
Five lakh 32,000.
Lordship. Well,
Issue notice making it returnable on 24th of September 2025. Ms. A. Gayan appears on behalf of the respondent number 1 and 2. Ms. Ardeka appears on behalf of respondent number 3, 4, 5, 6, and 7. As all the respondents are duly represented, extra copies of the petition be served by Monday date to the report. The petitioner herein is aggrieved that even after completion of the work pertaining to the protection of B dike from erosion of the river Brahmaputra from Ikomuk to Mukaloni, bracket Hikomuk and Rupohimuk area, bracket close. The petitioner have not been paid the balance amount of rupees 5,32,327 in spite of being represented on various occasions. The respondents herein are directed to bring on record their stand on or before the next date. They are the councils.
Lordship.
Kali naam tu badlai libo, huh? Notice making it returnable on 24th of September 2025. Mr. R. Gogoi appears on behalf of all the respondents and accepts notice. The petitioner, accordingly, extra copies of the petition be served upon him by 28, 7. It is the case of the petitioner that the petitioner have carried out 16 works under the scheme, namely Korayani PSS, Tengatoli PSS, Okesek, Trisguri PSS, Kub Bandemala PSS, and Ali Nagar PSS, issued by the respondent number 3 and 5. So out of the total amount of rupees 55,01,369 to which the petitioner claims to be entitled, only an amount of rupees 1,43,470 have been paid, and the remaining amount of rupees 53,57,899, though admitted, have not been paid, for which the petitioner has approached this court. The respondents are directed to bring on record their stand by filing their affidavits on or before the next day.
Finance department. Finance part is not being a party because the funds have to come.
You come up, we'll see. Same type D, 24 September.
Complaint certificate not to annex your lodge.
come up with that plea. Come up with the, yeah, etu khali complete kora nai. Mane yat eya nai, that etu teo koise complete kora boli. 50,000 and not been paid the amount of rupees. How much?
7,50,000 had, out of 7,50,000, my lord, 5 lakhs have already been paid, my lord.
Only 2
Only
lakh.
remaining,
The claim of the petitioner herein is that in spite of the fact that the petitioner had completed the work to the satisfaction of the respondent authorities, and the final bill of rupees 7,50,000 being submitted, only an amount of rupees 5 lakh had been paid, and there is an outstanding of rupees 2,50,000, which is pending.
additional 70,000, my
In
lord.
addition to that, the petitioner also claims that there is another amount of rupees 88,000, isn't it? 88.
There are two additional, 70 and 18.
So 88,000, to which the petitioner is entitled to. The respondents are directed to bring on record their stand by filing the affidavit. You are paying for everybody. Mission director also, na?
Except respond number 6, your lordship.
Who is paying for respondent number 6?
The chairman, DWSM come deputy commissioner.
Huh? Mission director?
Mission director. Six is the deputy.
R. Gogoi appears for respondent number 1. All the respondents except respondent number 6 and Miss Udas appears on behalf of the respondent number 6. By 28, except the name of Miss GSM be shown in the court list. Same matter.
My lord, there is a bill, my lord, admitted, my lord, at page, my lord,
Same date be?
13 to 15.
The claim of the petitioner in the instant writ petition is that the petitioner is entitled to an amount of rupees 1,85,506 in respect to a work order issued on 28/8/2020 by the executive engineer PHC Silchar. It is the case of the petitioner that the said amount, though admitted, have not been paid. And who are the parties? Same.
I'm from respond number 1 to 7.
Who appears? Not made the fishery department a party. I think fishery will be. Fisherman, I can put it. Issue notice making it returnable on 19th of September 2025. Steps be taken. Mr. T. Sharma appears and accepts notice on behalf of the respondent number 1 and 3. 1. And Ms. Yudas, the learning council appears on behalf of the respondent number 2, 3, and 4. And accepts notice. Extra copies of the requisition be furnished by 28/7/2025. The case of the petitioner herein is that the petitioner was settled with the Tengazan
Sengazan Group Fishery.
Group Fishery of Dhemaji district for a period of 7 years.
Case 22, three fisheries, my lord. All are for 7 years.
From
Case 22, my lord. There are three fisheries, my lord. On these three fisheries were settled with the petitioner. Case 22, Sengazan Group Fishery, number 22, Bangalmari Group Fishery, number 50, Bangalmari Group Fishery, number 22, Bangalmari Pabomari Fishery.
page
Case 22, my lord. There is the impugned order.
have been settled with the Sengazan Group Fishery, comma, number 50 Bongalmari Mari River Fishery and number 22 Bongalmari Pavomari Fishery for a period of 7 years with effect from
2000, my lord. From settlement.
the
order,
petitioner sought for remission of certain of the amounts on account of disturbances caused by the missing autonomous council, as well as on account of his ill health for which he could not operate the fishery. However, the respondent authorities have not conceded the said request for which the petitioner has approached this court. First, the respondents are directed to bring on record their stand by filing their affidavit on or before the next stage.
may not be disturbed in the meeting.
Not disturb, you don't pay, doesn't it? It's
That is why.
first and foremost, why you are having, if you are not well, why you are having free fishery? Think. Nothing, no bad case.
Problem.
I'm in a good mood, so issuing. note. Yes, same matter. All non-payment of dues today must have landed with Miss S.B. Chaudhary. Same order type A reason. He's appearing for respond number 8, I suppose.
6, here 6.
Yes, 6. I will back again. I'll follow the government of Assam's name may be reflected. Hey, Agota the decision. Yet whole pocha to the difference is go to people 1 lakh people now this is 8,95,000. Okay, Agota the order decision. Happening line. Belegan. Abijay. Who dilo batalo kita. Yes, why you are not paying?
Yes, Lordship. Telephoning instruction is that amount is admitted and.
No, there is no question of amount being admitted. Here is the question is,
Department.
on one hand, you want the
Yes,
security.
Lordship.
The fact is that first they will have to get the money, they will pay from them, and then you will reimburse. You are not reimbursing. What is this proposal? When you are initiating a tender process by way of a GM, and you don't know, you don't have a fixed fund that, okay, every year so we want 65 persons out there every month. So therefore, we have fixed this budget. There's no budget.
Yes, Lordship.
Then they will be, what do
Yes,
they
yes,
do?
Lordship.
How do they perform their work? Tell me. Now we'll issue a short notice on 1/8, next Friday. Issue notice returnable on 1/8/2025. Miss S. Sharma appears and accepts notice on behalf of the respondent number 1 and 2. Extra copies of the requisition be served upon her during the course of the day. The case of the petitioner herein is that pursuant to a NIT dated 8/10/2024, the petitioner participated in the said tender proceedings for supply of security manpower service for Kokrajhar Medical College and Hospital under the Health and Family Welfare Department. Full stop. The petitioner was selected and a work order was issued. Selected and a contract was awarded on 31/2025 for providing security with effect from 1/3/2025 to 28/2/2027. Full stop. In terms with the contract, the petitioner is required to provide 65 numbers of security personnel, which the petitioner have duly done so. Full stop. It is the further term of the contract that the petitioner first has to make the payment out of its own resources and thereupon have the respondent authorities have to reimburse the said amount. Full stop. It is the grievance of the petitioner that since the month of March and April 2025, the petitioner have not received a single penny. Now also you have not received a single penny. And the petitioner, out of their own resources, have already made payment for the month of March and April 2025. The petitioner's counsel for the petitioner expresses urgency, taking into account that the further proceedings have been initiated by the security personnel who have been employed on account of the non-payment of the dues by the petitioner in respect to the later months. Taking into account the urgency expressed, the learned counsel appearing on behalf of the respondent is directed to apprise this court as to why the said amount as claimed by the petitioner have not been paid, and if so, admitted when the said amount would be paid. Non-payment.
Non-payment. Home department.
Why you are going by temporarily?
Because Millet is pending since Millet would be 3 Millet.
Isn't it this police? Because temporarily it will be, they don't apply temporarily there. You want temporarily, we'll give you temporarily. Then later on, don't say that I have not got any money.
Because he wants to temporarily.
Huh?
My client, he wants to temporarily.
The client wants temporarily. Fantastic. Then you put it in the books. Whenever you have money, first verify. And then put it in the books. Whenever you have money, you pay. This is for police.
Police.
Yes.
Issue notice making it returnable on 10th of September 2025. Mr. S.R. Borua appears on behalf of all the respondents and accepts notice extra copies of the requisition be served upon him by 28/7/2025. The case of the petitioner herein is that the petitioner have performed his work of cleaning and repairing of septic tanks at Dhula PS, Panbari OP, Mongoldoi PS, Police Reserve L/S quarter, comma, Siampur PS, Pathorighat OP, and Bura OP. And the petitioner is entitled to an amount of rupees 14,89,500 against the said work. So in spite of the completion of the work to the satisfaction of the respondent authorities, comma, the respondent authorities have not paid the amount to the petitioner for which the petitioner has approached this court. The respondents herein are directed to bring on record the stand by filing the affidavit as to whether the petitioner is entitled to the said amount and or any other amount, and if so, when and how the said amount will be paid. No answer. Yes, what is this?
Matter pertaining subsidy.
Huh?
The matter pertaining to subsidy, which is to be issued by the respondent number 5 and 6, giving the NABARD for completion of construction of the rural godown, my lord. So what had happened in this case, my lord, the petitioner applied for one term loan for construction of a rural godown for a total project of 1.2 crores. Out of that, 40 lakh was invested by the petitioner and 80 lakh was issued through the term loan. Thereafter, your lordship, the respondent number 7, being the facilitator between the petitioner and the respondent number 5 and 6, applied for issuance of the first disbursement of the first subsidy amount of 16 lakh rupees to the petitioner. That was approved, and it was credited to the account in a separate reserve account, my lord. Thereafter, my lord, what happened? The joint inspection was also done by both respondent number 6 and 7 after completion of the godown. And there were certain observations that these things has to be done, that compliance was also completed, my lord. Upon completion of that compliance, my lord, when the final subsidy amount was to be released, my lord, at that moment, the respondent number 6 had recalled the earlier first subsidy which was issued also.
Earlier?
Earlier first subsidy which was issued was recalled, that this cannot be given to the petitioner. Now, the reason for that was shown that there was a circular which was issued by the respondent number 1 to 4, that the cutoff dates for sanction of the term loan was only 31st of December 2016, my lord. I'll bring that to that effect, my lord. And accordingly, my lord, the last application for disbursement of the subsidy amount was to be done by 28th of February 2016, my lord. Our application was given on 28th of March 2016. Now, there is a difference to that effect, my lord. The operational guidelines of that agriculture marketing infrastructure scheme which was given, that stated that from the date of disbursement of the first loan, within 90 days, the application had to be filed by respondent number 7 being the bank, with the respondent number 5 and 6 being the NABARD. Now, the petitioner was not given any formalities to complete that part, my lord, of applying that loan. So that operational guidance was very clear. Within 90 days, it has to be done. My loan was disbursed, my lord. First installment was disbursed on 29/12/2016, my lord. And within 90 days, that was applied by the respondent number 7 with the respondent number 6 for disbursement of the first subsidy amount, my lord. So that was within 90 days, which was done, my lord. Now, the reason for recalling of that first subsidy amount was that the cutoff date was given as 28th February 2017. My lord, I'll just draw the attention of the lordship to page, my lord, 44, my lord.
Now what has happened?
Yes, my lord, that.
What is your relief?
My relief,
You
my
are
lord.
asking for?
There is one important question of law that needs to be decided, my lord. One, my lord, at paragraph 27, my lord, at page 21st, my lord. importantly, my lord, the circular was given not taking into consideration their own operational guidelines, my lord. May I read, my lord? The petitioner states that the respondent number 5 are following the circular issued by the respondent number 1 to 4 over and above the operational guidelines of ISAM in light of the fact that the timelines set out as cutoff dates in the said circular are inconsistent with the timeline set out in the operational guidelines of ISAM. As the respondent number 1 to 4 have not considered the timeline set out in the operational guidelines at the time of issuance of the circular by receiving and sanctioning of the advance subsidy claim, and as such, there is an important question that needs to be that to that effect. When operational guideline is there that within 90 days the application had to be filed, while issuing of the circular, that 90 days were not considered, and the cutoff dates when setting out the cutoff dates that were not considered. Now, my lord, to that effect, my lord, I have drawn.
Wait, first and foremost,
My lord,
let's see what is the scheme.
my lord, that is at page
20
34,
29.
my lord, 29, my lord.
This is the integrated scheme for
Integrated scheme of
agricultural marketing. Okay. This is an operational guideline.
Yes.
Now, where is the scheme?
My lord, at page 44 is this clause which is given, my lord.
No, what are the benefits provided in the scheme?
The benefit of
Subsidy pattern,
subsidy
3.7,
construction.
page 40.
Yes, ma'am.
For storage infrastructure projects, northeastern states, rate of subsidy, 33%.
Yes, my lord. Yes, my lord.
Subsidy ceiling up to so and so. Now you are claiming in terms with 3.7.1.1A. Is it?
My lord, I have applied for construction of the rural godown, my lord.
Huh?
Construction of the rural godown,
What go down?
the rural godown.
Rule it. What is that? Where is it?
My lord,
It comes under what?
my lord, at page 41, my lord,
40?
41, my lord.
1. 41, what is this?
For
Infrastructure projects other than storage.
Infrastructure.
So you come under 3.7.2.
Two.
Okay. So there you get rate of subsidy on capital cost 33.33%. Maximum ceiling, subsidy ceiling is 5 crores.
Yes,
Okay. So this is it. Now ceiling is for this. Then,
my lord, at page 44, my lord,
uh,
at 3.10, my lord, the time schedule for submission of application and
Page?
completion of- Page 44, my lord. 3.10, my lord.
for submission of application and completion
of
for
project.
disbursement of the advance subsidy F1,
F1 financial institution, my lord, will.
FI will
Within 90 days.
within 90 days of disbursal of the first installment of loans, submit to RO NABARD
Is controlling.
through
and
its
nodal office.
controlling oblique nodal office.
If
A
brief
brief project
projects come
profile
claim form
claim form
for
for
advance
subsidy
subsidy in a prescribed form given in annex 9
or
along with
advance
documents.
subsidy in prescribed form in Iman along with the documents as per checklist at so and so. A copy of the claim form along with all the documents should also be submitted to the regional so and so. Will also inform the promoter about submission of the proposal to RO NABARD, and NABARD will every year compile a list of all proposals from all the projects. So it has to be submitted by the FI. Okay. Now FI will submit within 90 days of the first installment of the loan, which is being taken for the purpose of construction of that infrastructure. Now, it is the duty of the FI to be submitted to NABARD, and then it will be proceeded with. Your grievance is that you did not submit is the reason for which they respond number 6 and 7 have denied your entitlement. Isn't it? Who has applied? They applied later on. And because of that, you have not been granted the subsidy. Isn't it? So here, therefore, the case, the formulation is this. The operational guidelines puts a responsibility upon the financial institution to submit the application within 90 days from the date of the first installment of the loan to NABARD, and thereupon the process will start. In the instant case, the FI, that is the respondent number 7, submitted not on 28/2/2000 so and so, but it was submitted on 28/3, and thereby you have been deprived of the benefit. Although 28/2 or 28/3 is not mentioned, the only thing which is mentioned is 90 days. That's the long and short. Why so fat file? Yes, Mr. Dutta. You are for?
This is the question, my lord. They have, the claim was made after 90 days. So therefore,
Who makes the claim?
my lord, we have given in our affidavit.
No, no, show me in the operational guideline, who is to make the file the application?
The SBI will, my lord, give it to us within the time.
You are for NABARD.
I'm for the now.
Who is for SBI?
SBI, Mr. He is also as the.
And who is appearing for any other party? Industries, union? Who? No union. Union has no role. Has role?
One prayer to that effect, that my lord, then the circular was issued, my lord. At that time, the operational guideline 90 days was not considered. Only that to that.
Lordship, may I take it for final hearing?
Am I taking for anything else, Mr. Dutta?
I thought, my lord.
Chalo.
Then SBI, the presence should be necessary, I think.
Heard Mr. S. Sancheti, the learned counsel appearing on behalf of the petitioner, and Mr. S. Dutta, the learned senior counsel, appearing on behalf of the respondent number 5 and 6.
Yes.
The petitioner herein is aggrieved by the non-payment of the for non-consideration of its claim for subsidy for in respect to the construction of roller godown, which comes within the ambit of clause 3.7.2 of the Integrated Scheme for Agricultural Marketing (ISAM) issued by the Ministry of Agriculture, Department of Agriculture and Corporation, New Delhi. The case of the petitioner herein is that the petitioner's application have not been considered on the ground that there has been a delay in submission of the said claim application. First, the learned counsel, drawing the attention of this court to clause 3.10.1, submits that it is the duty of the financial institution, and in the instant case, the respondent number 7, to submit within 90 days of the disbursal of the first installment of the loan to the respondent number 5 and 6 through its controlling nodal office, a brief profile come claim form for advance subsidy in the prescribed form. along with documents as mentioned in Annexure Roman 9 and Roman 10 respectively. He therefore submitted that the fact that the petitioner is entitled to is not in doubt, but it is on account of the delay in submission of the application by the respondent number 7, who is the financial institution. The petitioner has been deprived of the subsidy, and it is under such circumstances the petitioner has approached this court. First, this court takes note of that though the respondent number 5 and 6 is represented, but the respondent numbers 1 to 4, under whose aegis the said subsidy scheme have been initiated, subsidy scheme have been made, and the financial institution, that is the State Bank of India, is not represented today when the matter is called. Considering the above, comma, this court for the ends of justice grants another opportunity to the respondent numbers 1 to 4 as well as the respondent number 7 to present their case before this court. First, let this matter be again called up on 16th of September 2025. First, it is observed that if in the circumstance the respondent numbers 1 to 4 as well as the respondent number 7 is not represented, comma, this court shall dispose of the instant petition on the basis of the materials which are already available on record.
My lord, the petitioner, one of the claimant being the mother of the my lord claim, and the claim petition was settled before the my lord in the Loca Adalat organized by the District Legal Service Authority, Kamrup Metro, my lord. My lord, page 28 is the my lord imprint order, my lord. But the my lord overlooking the right of the petitioner, my lord.
Who are you?
And the mother of the my lord victim, my lord. And the my lord.
So your dispute is against the mother?
So my lord, I am the mother,
Ah.
but the claimant number 1, the wife of the my lord victim, my lord would earn the money, my lord. As per the my lord, dated my lord, legal service authority in the Loca Adalat.
No, tell me first of all, both of you were the appellants in MSC case number so and so? You were the claimants?
Claimant
So
number-
then there was a Loca Adalat, where there is an agreement being made that 10 lakhs is the amount which is to be paid. You have no quarrel with the quantum. No, do you have a quarrel with the quantum? So therefore, you don't have a quarrel with the settlement. Because you don't have the quarrel with the quantum. You were a claimant in MSC case number 135?
and claimant number.
So you don't have a problem with the settlement of the rupees 10 lakhs. Now what has happened, as per your allegation, that amount has been taken by the daughter-in-law.
Because I have not been informed regarding the my lord settlement. So my lord, I have my lord quarrel with the my lord quantum, my lord. I am disputing my lord. Because before settlement, I have to issue notice, but no notice was issued to me.
Huh?
My lord, before settlement, my lord, my consent is required, my lord, but I have not been consent in the settlement, my lord.
So you are challenging the settlement.
Enter order, my lord.
Hmm?
Page 28, my lord, Annex 3. Only claimant number
Who
1.
filed the claim petition?
My lord, claim petition is page, my lord, 15 start, my lord.
Hmm.
And the claimant number 2, Saleha Khatun. And claimant number one, Nazima Khatun, is the wife of the victim.
Now you have objection as regards this. So the claim petition which was being filed, was your lawyer present when the
My
proceedings
lord,
were going on?
my lord, Sri Tutul Kolita, not signed in the Okalat Nama, but he identified before the my lord Loka Adalat.
Huh?
My lord, kindly see page, my lord, 27.
27 is the Wakalat,
Wakalatnama,
22.
sir.
22 is the Wakalatnama.
27 is the Okalat Nama, three councils are signed. One, my lord, Sri Utpal, Dr. Utpaljit Barua, Sri Utpal Burman, and Mrs. Ranju Rekha Sharma Barua. And Tutul Kolita name is mentioned in the ballot printed Wakalatnama, but not signed. Then, my lord, can you see page 28? Identified the, my lord, before the Loka Adalat, my lord, Tutul Kolita was identified.
Where?
Page 28. He is not the, my lord, Angus council.
So have you filed a case against those councils who were present, whom you have signed the Wakalatnama?
No.
Why? Filed a case before the Bar Council against these three councils? How this has happened? Because they were also equally responsible. Did you ask them what has happened? Did they say that they have, this Tultul Kakoti have done it without authority?
Approach, but they did not respond. Approach, but they did not respond, give any response.
Where have you mentioned?
I have not mentioned. because
Don't,
they
Mr. Counsel, this type, that is why I have, Mr. Saikia, what the problem which arises, I don't sit in the Loka Adalat, you see. Earlier I used to sit. The reason why I don't sit in the Loka Adalat is there is a process which is being done that the council will appear. And the judges out there take these councils in good faith that, okay, they have due right of representation. But I always insisted that the party has to be present. Now, what happens? These are all pre-litigational. There is already a pre-litigational, the pre-Loka Adalat settlement. When this pre-Loka Adalat settlement happens, these people are very well present. This is how you do it. Now, here, the daughter-in-law accepts it. She must be there. Now, this person has now raised this issue. This has happened in the year 2019, and you filed the writ petition in 2020. So now he has the problem as regards the settlement. Once a settlement has happened, therefore the sanctity in the settlement order has been now put challenged on the ground of these, the lawyers accepting or sending their juniors out there. This is what keeps on happening. This is a very serious issue. In fact, the insurance people should be very careful. This is one case, then there are many other cases which keeps on happening. In fact, that day, this very council was filing on behalf of another, this council, this this Utpal Burman had filed a case against, he is appearing for Mahendra against some lawyer. Some insurance company that this couldn't have been done and all this thing. This settlement has been done illegally. The lawyer had accepted it without any authority. So this is a big problem which is being faced now. And there is always a hurry to show that how much disposal we have done, how much amount have been settled. But at the end of the day, you find this big problem which arises if the parties are not, all the parties. Okay, then we do one thing. We will interfere with this type. But we make it a point that in all cases, all the parties have to be present, otherwise there cannot be a Loca Adalat in Guwahati. And this is going to affect you. You also appear in the Loca Adalat. And there you don't get your client. Remember that. This is being done. That is why I don't appear in the Loca Adalat. I don't do it. Earlier I did for 2 and I said that unless the parties don't come, I'm not going to.
Insurance company also not identified whether my presence is there or not, my lord, because only identified by the claimant number 1, Najma Khatun, and my presence, my lord, they overlooked them and my presence.
What your presence?
Before
The
local.
problem arises that are you in talking where does this lady stay? The wife? The wife, the person who took the money?
Now she, my lord, reside in her maternal house, my lord. In her maternal house.
She doesn't stay with you.
But claim petition both were from the same house.
Huh?
Same
At the time of
as per claim
petition,
petition, both were residing in the same.
Then
As per claim petition, Lordship.
now you have a problem with it. When did the respondent number 1 shift?
My lord, after settlement of the, my lord, she left. When I asked, my lord, Tera 9, she altercated with me regarding the, my lord, tax status. So
What
I
is the
raised-
altercation?
Altercation, my lord, she,
Where is your statement?
well, Tera 9, my lord.
We will hear that your lady
My lord.
have her personal appearance.
That-
That would be.
Mother-in-law and daughter-in-law, Lordship.
No, I think the best way is get hold of her. Well, you may not be surprised. She may not be even knowing about filing of the claim. I've been there in the bench one for a very, very long time. Because then she will be knowing it. I had the opportunity when the Loca Adalat goes on. You're surprised. There are cases where, because of the judgment in Nangjappa, which stipulates that you have to pay a particular amount in certain installments and all these things, or put it in the fixed deposits. The claimant says that, okay, we will, if it is a 50 lakhs, we'll go for 30 lakhs, but it should be a one shot. Insurance is happy. They are paying just 30 lakhs. Fantastic. But remaining is this. But with this one shot, what happens to the money, nobody knows. Chalo, recalling this here. What is the order being passed here by the court when you file the recalling?
My lord, refused to accept the petition, my lord. Okay,
Then why have you not filed 227? Why 226? How can I exercise jurisdiction? First of all, this Loca Adalat, the order has been passed there. I may have the jurisdiction, but the jurisdiction is under 227, only to direct them to look into that. Because this is the finding of fact which has to be arrived at, whether all the both were present or not. You have to prove it. Who then? But why should I interfere in a 226?
fixed another date, I'll explain.
Why?
my lord.
We have spent so much of time now. You first bring on record what action you have taken against those three advocates who had signed the wakalat. And then we are going to take it. Full stop. Lekhok heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. A.J. Saikia appears on behalf of the respondent insurance company. That's why insurance company. Full stop. None has appeared on behalf of the respondent number one. The petitioner herein have assailed the legality of the award dated 14/9/2019 passed in the National Loca Adalat held on 14/9/2019 by the member Motor Accidents Claims Tribunal, Kamrup Metro at Guwahati. It is the allegation of the petitioner that the petitioner, who was one of the claimants in MSC case number 135/2018, was not consulted before settling the said proceedings. And the respondent number one unilaterally settled the said proceedings and took the entire amount. The petitioner further questions the authority of the person, the advocate, whose signature is there in the said order dated 14/9/2019 on the ground that the said authority person, the said advocate, was not authorized by the petitioner. This court duly takes note of that the said MSC case number 135/2018 was filed by the petitioner along with the respondent number one, claiming compensation on account of the death of the son of the petitioner. In the said proceedings, as it appears from the wakalatnama, so executed by the petitioner and as well as the respondent number one jointly, 3 advocates were appointed, namely Dr. Utpaljit Borua, Mrs. Ranju Rekha Sharma Borua, and Sri Utpal Bormon. Full stop. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether there has been any inquiry being made with these 3 counsels who were appointed to take care of the interest of the petitioner in MSC case number 135/2018. The learned counsel submits that on inquiry being made again with these counsels, these counsels have not ignored the requests so made by the petitioner. Full stop. If these allegations are true, it is a serious case of misconduct on the part of the advocates. Full stop. Under such circumstances, this court inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner have lodged any complaint before the bar council before the bar council as regards the conduct of these 3 advocates, along with the advocate who had signed on behalf of the signed in the order dated 14/9/2019. Full stop. He submits that he has no instructions in that regard. You have instruction? No instructions. Full stop. Taking full stop. It is observed that these allegations, this court finds it very pertinent to observe that the manner in which the challenge has been made to the order dated 14/9/2019 passed in the National Loca Adalat, if allowed without there being a seriousness, without there being materials substantiating that the petitioner is actually challenging the author is actually aggrieved and without the petition, if allowed to be challenged, comma, without proper materials, questioning the authority of the advocates who were appointed by the petitioner, comma, the very sanctity of the settlements so made in the national Loca Adalat would be rendered nugatory. Considering the above, comma, this court fixes this matter again on 27th of August 2025. In the meantime, the petitioner herein is directed, the counsel for the petitioner herein is directed to obtain instructions as to whether any complaint have been made against the four advocates, the three advocates whose name appear in the Wakalatnama of MSC case number 135 of 2018, as well as the advocate who appeared, who signed on behalf of the claimant in the order dated 14/9/2019. List according.
Highly obliged, Your Lordship.
Next matter will be. What is this? Non-payment.
It's been listed after so long time, my lord. So, matter may be fixed next week, my lord. I'll take instruction whether it is in what stage, my lord.
He says payment not made. So verify and pay.
That can be done.
Verify, pay 6 months.
It says no supply was paid.
Admitted.
No supply,
No supply.
no records found.
There is no, it is not no supply. It says there is no record of supply. So if there is no record of supply, obviously you cannot admit. So you'll have to go before the civil court. To go before the civil court. Heard Mr. M. Barbhuya, the learned counsel appearing on behalf of the petitioner. Mr. S. Dutta, the learned counsel appears on behalf of the PNRD department. And Mr. S.R. Borua, who appears on behalf of the government of Assam. Full stop. The petitioner herein has approached this court by filing the present petition, challenge being aggrieved by the non-payment of the dues of an amount of rupees 6,24,074, which the petitioner raised by bills dated 10/5/2018. Full stop. It is seen that this court, by an order dated 14/7/2020, had issued notice. Full stop. Mr. S.R. Borua, appearing on behalf of the respondents, have produced an instruction dated 28/9/2020, issued by the secretary, Dhoria Ghat Korisera Gaon Panchayat, wherein the petitioner alleges that he had made the supply. That there is no records available that any such supply of materials was made to the said Gaon Panchayat. So the said document is kept on record and marked with the letter X. You give me a photocopy of this, huh? I can do a photocopy. First, taking into account the above, comma, this court, in exercise of the jurisdiction under Article 2 to 6, would not be in a position to adjudicate as to whether the petitioner can be directed to make payment, can petition as to whether can in exercise of the jurisdiction under Article 2 to 6 cannot direct the respondent authorities to make payment to the petitioner of the amount so claimed in the writ petition, as the very statement made by the as the stand of the respondents is that there is no records available of such supply. Considering the above, comma, this court is not inclined to issue any writ in the instant proceedings. Be that as it may, comma, this court grants the liberty to the petitioner to approach the civil court of competent jurisdiction, and the period from, if so advised, and the period from 19/6/2020 till date be excluded while computing the period of limitation. Hello.
Serial number 3 Lordship has expressed Lordship's mind. There are two other thing is also there. In serial number,
Not necessary.
no, if Lordship,
One is enough.
no, that is correct Lordship. But if Lordship affirm this 4 and 5 finding, then it will affect our future prospect Lordship. And it is an absurd. I'll take only 10 minutes Lordship. That 4 and 5 Lordship. If Lordship see the 4 is annexer E, and Lordship that we have at page 137. That document-
Annexer is not in letter head.
that is why this is not applied. to
How is it going to have any bearing in the future?
Lordship. Kindly see, this is not applied to us. Why? For a moment, Lordship, that's 137.
I will only decide only on 3.
No, three is.
Three.
If Lordship affirm this
Enough.
one, now Lordship,
I've heard you enough yesterday.
no. 4 and 5
Enough
Lordship.
really.
4 and 5 Lordship. 4 and
5 is notarized. You had to give a lease deed of 1 year. And 1 year it is notarized, is not a registered deed. So as per you, it should have been a registered deed.
The finding is that it is section 17(1)(d), violation of section 17(1)(d). But section 17(1)(d) doesn't apply in my case, because it is a lease deed for a 1 year. If for a 1 year for a fixed period, then section 17(1)(d) does not apply.
You are disqualified.
No.
Technically, rightly disqualified. Okay,
No,
let me do.
this one because,
Enough.
no, Lordship, for a moment, Lordship.
I know. The remaining, keep your breath and energy for going to the division bench.
For that, Lordship,
Heard
Only-
Mr.
only
J.
one-
No, nothing.
only one submission.
Mr. Deka, I've heard you yesterday. Enough. Only Mr. Biswas, what do I do as regards the direction as regards the representation of his? That is what I wanted your submission.
Just please you dates, because the dates is due some importance with regard to the representation. My lord, on 21/9/2024, both of us were declared as qualified. Immediately on 23, sorry, my lord, yes, we did. On 23, within 2 days, I filed a writ petition saying that there are this anomaly. The court on 24th gives me directs me to file a representation within 3 days and the representation to be disposed of. So my lord, on the date when I filed the representation, I was a qualified bidder. Filed the representation, now acting on the representation, the respondent has passed that order 409 order there. Now my lord, now the date 24, the minutes where he was technically declared as unqualified is 30 September 2024. Now, my lord, he files a representation, the representation which he is speaking about now, on 7th of October. That is on a date when he was technically disqualified. He did not challenge my bid when both of us were qualified. He was completely silent. This is on 7/10, he files his representation and he expects the department to dispose it off in 1 day because on 8th, he moved unlisted the present writ petition. Now, my lord, and our representation was immediately 24/9 and 25, we have filed 24/9 was the High Court order, 25/9 is our representation order. So on the date when they are making this representation or when they are challenging this particular writ petition, they have already been declared unqualified. This is one. Second, my lord, yesterday, my lord, I will respond to this because a submission was made touching upon the council. They said that there was some collision. Now, my lord, the district.
Not this.
Because,
Next.
so, my lord.
My only question to you was specific.
Yes.
That should I direct the consideration of his representation insofar as cancellation of your bid. I understand what you want to say first. That look here, it seems to be an afterthought because he did not at the time when he was selected, he was technically qualified along with you, had any objection as regards your qualification. He did not. After getting an order also by this court on 24/9, then also he did not take anything. When it was decided on 39, then also he did not. Then on 7/10, after having been disqualified, now he files it. So therefore it is an afterthought, so there is no question. And more particularly, an unqualified bidder could not. That is one. And anything else?
And anything else, my lord, because they were, it was their case. They argued yesterday that the representation ought not to have been made before the district commissioner because there is some provision in the authority. So their representation is also before the same authority. So by their own argument, that representation deserves no consideration. That's only small reply.
It is not fair, Mr. M. Biswas, when a person is in a deathbed to kill someone so much. Okay, now enough. No reply. Take your seat. I've heard you yesterday from 4:20 to 5:10. Heard Mr. J. Deka, the learned counsel, appearing on behalf of the petitioner. Mr. R.R. Gogoi appears on behalf of the respondent numbers. There are two petitioners. On behalf of the petitioners. And Mr. R.R. Gogoi appears on behalf of the respondent numbers 1 to 6, 1 to 5. Mr. M. Biswas appears on behalf of respondent number 6. And Mr. N. Deka, you appear for this one also, 12 also, na? 12. Itu dhara dibo, ha? 12. And Mr. N. Deka appears on behalf of the respondent number 7 to 11. The petitioner herein have challenged the technical bid of the respondent number 6 by way of the present petition and further sought for a writ that the decision so taken, for setting aside the decision so taken, to hold the technical bid, e-bid of the petitioner non-responsive. The petitioner has also sought for a direction that the respondent authorities be directed to accept the petitioner's number one's technical e-bid and open the financial bid. It appears from the materials on record that the respondent authorities, more particularly the office of the district collector, which district? Respondent authorities, more particularly, who has issued this notice inviting tender? District collector, which one? It appears from the records that the district collector, Lakhimpur district, had issued a tender for e-bidding for IMFL off license at Narayanpur town, Lakhimpur district, bearing tender reference number EXCI oblique 679 oblique 2023 dash all caps excise dash LKPR. Before further dealing with the facts involved, it is relevant to take note of some of the clauses of the notice inviting tender. Clause 6 of the said notice inviting tender, for short the NIT, stipulates the documents which would comprise the bid. Clause 7 stipulates as to how in clause 6, of the said NIT, there's a reference to various documents. Amongst them, relevant herein for the purpose of the instant dispute, is clause 6.2.27 Where's the Bakita clearance certificate? Yours? 6.2.15 serially করে দিব 6.2.15 police verification 6.2.20 medical certificate of health कितने of the 6.2.19 and 6.2.5 এইকেইটা serially কৰি দিব আগৰ পৰা আনি পুস্তক the said clauses are quoted herein under page 59 60 and 61 of পাব huh? Clause 7 stipulates the procedure to apply. In terms with clause 6, 7.6, all pages of the document submitted by the bidder is required to be signed by the authorized signatory and shall also be affixed with the bidder's entity stamp. The said clause, being relevant, is reproduced herein under. A further perusal of the said notice in the NIT would show that the bid has to be would be of two separate parts, that is technical and financial bid. And the financial bid would be open if a bidder is technically qualified. In the backdrop of the above, it is relevant to take note of that against the said tender, the petitioner as well as the respondent number 6, the petitioners as well as the respondent number 6, petition number 1 as well as the respondent number 6 submitted their e-bids. The record reveals that on June 9, 2024, the petitioner as well as the respondents' bids were open. Just inform me if the date is wrong, huh? Respondent number 6, petitioner number 1 and respondent number 6 bids were open. And in spite of shortfall of certain documents, the petitioner number 1's technical bid was held to be qualified. First,
Page 21, page 307. Page 307.
no, it was opened on 2/9.
However, the minutes of the meeting is 21.
On 2/9/2024, it was opened. And on 21/9/2024, it was opened on 2/9/2024. And on 21/9/2024, in the minutes of the meeting of the technical committee, it was held that the bids of both the petitioner number 1 and the respondent number 6 were found responsive. Full stop. On the ground that the bid, the respondent number 6 having noticed that various documents were not submitted, that the bid so submitted by the petitioner number 1 was not in terms with the NIT, immediately approached this court by filing a writ petition, which was registered and numbered as WBC number 4971/2024, challenging the acceptance of the technical bid of the petitioner number 1. First, the learned coordinate bench of this court passed an order on 24/9/2024 thereby permitting the respondent number 6 to submit a representation before the District Commissioner Lakhimpur on the aspect or on the grievances of the respondent number 6 as regards the bid, technical bid so submitted by the petitioner number 1, and further directed the respondent, the district commissioner Lakhimpur to take a decision on the said representation submitted by the respondent number 6 within a further period of 1 week and communicate the said decision to the respondent number 6. It is further directed that till such decision is taken, the district commissioner, collector, Lakhimpur, was directed to maintain status quo with regard to the NIT dated 24/7/2024. Admittedly, till the date, on the date on which the order was passed by the learned coordinate bench, that is on 24/9/2024, the financial bid was not opened. Full stop. It is very pertinent at this stage to observe that the petitioner herein did not question the responsiveness of did not question the responsiveness, the minutes of the meeting dated 21/9/2024, wherein it was found that the respondent number 6 bid was also responsive. First, the record reveals that pursuant to the said directions passed in the order dated 24/9/2024, the technical committee again re-evaluated the technical bid of the petitioner and found out that there were 3 deficiencies in the said bid. First step. The observations, the details of the said, the findings of the said technical committee, evaluation committee, being relevant, is reproduced herein under page 410 of the টেবুলখনৰ ভিতৰত আছে সেইখন হয়। Full stop. From a perusal of the above, findings so arrived at by the technical evaluation committee, it is seen that though the respondent number 6 have alleged that there were 5 deficiencies in the technical bid of the petitioner number 1, but the technical evaluation committee accepted the 3 of the objections which are mentioned at serial number 3, 4, and 5 as would appear from the table herein above. First, the petitioner, having been informed that his technical bid was non-responsive on the basis of the evaluation done on 30/9/2024. The petitioner submitted a representation on 7/10/2024 to the respondent number 3, to the district commissioner, to the respondent number 2. Deputy, you have not made the district collector a party. My goodness. Huh? Where? Where's the district collector party? Deputy commissioner. Where's the district collector? The tendering issue notice, you have not made him a party. I'm not now there, but who is the tendering authority? The district collector submitted a representation on 7/10/2024 to the respondent number 2 and 12 of the present proceedings. Full stop. Immediately on the next date, the present writ petition was filed. That is on 8/10/2024. Full stop. The record reveals that this court, by an order dated 8/10/2024, while issuing notice directed in the interim that the financial bid of the petitioner be opened along with the bids of other bidders on the scheduled date of opening of the financial bid, and the tender in question shall not be finalized without the leave of the court. The interim order thereupon have been extended from time to time. The record reveals that the respondent number 5 had filed an affidavit in opposition, wherein it was mentioned, wherein the minutes of the meeting of the technical evaluation carried out insofar as the petitioner is concerned, number 1 is concerned, have been enclosed. The minutes of the technical evaluation of the petitioner dated 30/9/2024 have been enclosed. First, It is seen from the materials on record that this affidavit in opposition was filed by the respondent number 5 on 7th of March 2025. But the petitioner have not assailed the said minutes of the meeting. First, it is further seen that the respondent number 6 as well as the respondent number 7 to 11 have also filed their affidavit in opposition. However, taking into account the parameters within which this court is going to look into, is going to adjudicate the present dispute, this court would not like to refer to the same as does not feel the need to look into the said averments contained therein. First, in the backdrop of the above, let this court now take note of the submissions so made by the learned counsel appearing on behalf of the petitioner. Mr. Jaitika, the learned counsel appearing on behalf of the petitioner submitted that the order which was obtained by this court, from this court dated 24/9/2024 in WPC number 4971/2024 have been obtained by misleading and as such, on the basis of the said order, the petitioner could not, petitioner's bid, which was otherwise earlier held to be technically responsive, technical bid, which was earlier held to be technically responsive, cannot be held to be technically non-responsive. The legal counsel further submitted that there is a cartelization insofar as the respondent number 6 with the respondent number 7 to 11, or which the respondent authorities failed to take into consideration. And as such, the bid of the respondent number 6 ought to have been cancelled. The respondent, the learned counsel further submitted, drawing the attention of this court to clause 15.1 of the notice inviting tender, that no bidder should be permitted to refer to the learned counsel appearing on behalf of the petitioner, further referred to clause 15.1 of the NIT and submitted that the bidders cannot contact the district collector or the tender of the bid committee on any matter relating to his e-bid from the time of bid opening to the time of issuance of letter of acceptance. And as such, submitted that the petitioner, the respondent number 6, could not have approached the district collector. And further referred to clause 29.1 and submitted that the respondent number 6, if so agreed, could have only approached this court as this court had the exclusive jurisdiction. The legal counsel for the petitioner further, referring to the order passed by this court on 24/9/2024 in WPC number 4971/2024 submitted that as the exclusive jurisdiction vested upon this court would not, a mistake was committed in the order dated 24/9/2024 in permitting the respondent number 6 to submit a representation before the district collector. The legal counsel for the petitioner further submitted that once the petitioner number 1 was held to be technically responsive, without hearing the petition, giving a hearing to the petitioner, the respondent authorities could not have come to a finding that the petitioner's technical bid was not responsive. Anything more? Don't come up with all this otherwise. The learned counsel further submitted that the decisions were taken on 39/2024 in the minutes of the technical evaluation committee meeting, more particularly at serial number 4 and 5, has no relevance and is a decision based upon malice in law. Per contra, Mr. R.R. Gogoi, the learned counsel appearing on behalf of the respondent authorities, submitted that the technical bid committee, while evaluating the tender initially, upon opening the tender bids on 2/9/2024, found that the bid of the petitioner number 1 was wanting from various documents. And as such, on 18/9/2024, the petitioner number 2 was informed about the said aspect of the matter. The petitioner number 2 thereupon submitted an affidavit on 29/2024. Based on the said affidavit, in the minutes of the meeting dated 21/9/2024, the petitioner as well as the number 1 as well as the respondent number 6 were held to be technically responsive. He further submitted that the respondent number 6, without submitting a representation to the concerned respondent authorities, directly approached this court by filing the writ petition being WPC number so and so. And this court, by an order dated 24/7/2024, directed the consideration of the representation. First, the learned counsel submitted that pursuant to the representation submitted, it was duly taken note of that there were 5 objections raised by the respondent number 6 to the technical bid of the petitioner number 1. First, of the 5 objections, 2 objections were rejected. First. However, the 3 objections so raised were found to have merit, taking into account the bids so submitted by the petitioner. First, the senior counsel appearing on behalf of the petitioner, a respondent authorities, further referred to clause 6 points so and so. Submitted and drawing the attention of this court to those clauses, clauses so and so. Submitted that these documents were required to be submitted. And in terms with clause 7.6, these documents had to have the signature as well as the stamp of the respondent number 1, of the petitioner number 1. First, he submitted that admittedly, the bid which was submitted by the petitioner number 1 did not conform to clause 7.6. And if these documents in question are not under the signature, which are not under the signature and stamp of the petitioner number 1, the same could not have been taken into consideration. And as such, the bid of the petitioners was rightly held to be technically non-responsive. Anything more? Mr. M. Biswas, the learned counsel appearing on behalf of the respondent number 6, submitted that the allegations so made by the petitioner in respect to the order dated 24/7/2024, 24 is not only misconceived, but also contemptuous. He submitted that if the petitioner was aggrieved with the said order, the petitioner ought to have challenged the order in an appropriate forum rather than making such allegations. He further submitted that the reference so made to clause 15.1 and clause 29.1 of the NIT is further misconceived, in as much as clause 15.1 is in reference to is in connection with that the district collector as well as the tender committee should not be disturbed, should not be contacted pursuant to the bid documents being opened until the letter of acceptance is being issued. Full stop. the learned counsel further submitted that the submissions so made, reference so made to clause 29.1 is further misconceived and untenable, taking into account that without demanding justice, comma, a writ of mandamus cannot be issued. And as the petitioner, respondent number 6, did not submit the representation, this court, in all fairness, directed submission of the representation and for consideration thereof. He further submitted that upon the order being passed by this court, the technical committee, evaluation committee, have looked into the deficiency and found that there were 3 deficiencies in the said technical bid, so submitted by the petitioner number 1. First, the learned counsel further submitted that this very document have also not been put to challenge. First, the learned counsel for the respondent further in addition to that, the learned counsel for the respondent number 6 submitted that the filing of the representation on 7/10/2024, just 1 day before the filing of the writ petition, is nothing but an afterthought. After coming to learn that on 30/9/2024, the petitioner's bid was held to be, technical bid was held to be technically non-responsive. Anything more? I've heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. Footstep. In the foregoing segments of the instant judgment, this court have duly taken note of the various clauses wherein there is, which stipulates the necessity of submission of certain documents. It is also seen from clause 7.6 that all these documents had to be signed and put under the seal and stamped, signed and stamped by the bidder. First, it is an admitted case that the petitioner's bid did not contain the signature in the documents which are in connection with, which were mandatorily required to be submitted in terms with the clauses referred to herein above. First, this court further takes note of that though the respondent authorities earlier have held that the petitioner's bid was technically responsive in its minutes of the meeting dated 21/9/2024. But taking into account the order dated 24/9/2024, passed in WPC number so-and-so, 4971/2024, and the representations were submitted by the petition, by the respondent number 6, the technical evaluation committee was bound to look into those objections so raised. Footstep. The technical evaluation committee, upon looking into the objections, found out that the petitioners were deficient on 3 parameters as set out in the order in the minutes of the re-evaluation meeting dated 30/9/2024. First, this court further takes note of that this court at this stage, this court finds it also pertinent to take note of that a submission so made during the course of the hearing by Mr. J. Decker to the effect that the signature being not there in those documents, signature and stamp being not there in those documents, would have no material bearing, as well as the submission that the petitioner was not given an opportunity before arriving at the decision on 30/9/2024. It is the opinion of this court that when the tender conditions specifically stipulate that the said documents were required to be signed and had to bear the stamp of the bidder, the said documents having not been signed and do not carry a stamp of the bidder makes, and having not been signed in here, the said documents which are not signed and bears the stamp of the bidder cannot be taken into consideration as a valid submission of the said documents. First, in this context, this court further finds it pertinent to take note of that the doctrine of useless formality, which stipulates that the principles of natural justice would not apply in the circumstance where even if an opportunity of hearing is given, the course of action which would have followed would not change. Full stop. In the instant case, as admittedly the documents in question did not bear the seal and the signature as well as the stamp of the bidder, an opportunity being given of hearing would not change the course of action. First, consequently, it is the opinion of the court, the minutes of the re-evaluation committee held on 30/9/2024 cannot be faulted. And accordingly, the question of a judicial any interference in exercise of power under Article 2 to 6 of the Constitution does not arise. First, let this court now take into consideration as to whether there should be a direction issued upon the respondent authorities to consider the representations so submitted by the petitioner insofar as the bid of the respondent number 6 is concerned, It is relevant to take note of that on 21/9/2024, both the bid of the petitioner, the technical bid of the petitioner number 1 as well as the respondent number 6 was held to be technically responsive. The respondent number 6 being aggrieved filed a writ petition before this court, and on the basis of which the order dated 24/9/2024 was passed. However, the petitioner did not do anything. The petitioner waited till the decision is arrived at on 13/9/2024, and thereupon on 7/10/2024 had submitted the representation and in the status of unqualified bidder. Considering the above, it appears that the representation so submitted by the petitioner was an afterthought, and more particular, and further, the representation was submitted by an unqualified bidder. In that view of the matter, the question of direction being issued on the basis of a representation submitted by an unqualified bidder does not arise. In that view, considering the above, as this court does not find any merit in the instant writ petition, this court dismisses the instant writ petition. Further to that, taking into account that there has been a stay, how much loss you are having per day? Cost? You are not working now. You have lost some taxes and all excise. How much? 25 lakhs?
Exactly.
How much? 20 lakhs? Cost of? Cost of? Cost? You knew it on 27/5/3. Yes, it is on affidavit. Don't, Mr. Deka, kindly come to, don't make the submissions like this. No. First of all, that is why I mentioned in my order itself that affidavit was filed on 25/3/2025. What were you doing? Interim order passed earlier stands vacated, comma. The writ petition stands dismissed with cost quantified at 10 lakhs, 5 lakhs, 2 lakhs, 1 lakh. No cost.
I'm deeply obliged.
Yes, Mr. Chaudhary, your motion matters.
Item number 1, three, same matter. Well, straight away, I'll take your lordship to the relevant clause.
The others also may be having that clause. Show me in any of these Rana,
Yes.
all these are Rana
No,
construction.
no, no. Let's come to page 26.
Bench 4 must be running on Rana construction.
One more.
And Muslim Ali.
Not even but bidder at the bidder's own responsibility and risk is bound to visit and examine the site of the works.
Where, which
Page
clause?
26, 7.1.
Where's the tender? And
This is part of the tender, I think
page
7.
21.
It starts
Ah.
at 21.
Site visit.
Yes, site visit. Bidder at the bidder's own responsibility and risk is bound to visit and examine the site of works and its surroundings and obtain all information that may be necessary for preparing the bid and entering into for entering into contract for construction of the work. Now this is important. The bidder shall obtain a mandatory site visit certificate with verification from the concerned engineer authenticating his visit to the site of the work and submit the same along with the bid. So unless the
Who is the concerned engineer? Is it?
10:30 on Monday, my lord. There's the last wipe. I will have it by 10:30.
Hmm. You do one thing. You see why you are having it. The site visit clause is only for the purpose that later on he should not say that I have not visited the site and I did not know all these things. So your basic idea is that person, if he does, because later on what happens, oh, this site was not properly done and all these things, difficulty. That is why you have this particular clause.
No. 10% less than the estimated cost. Now that has removed, this has been brought. The idea is you should have a fair amount of idea what is the work. Later in you don't feign ignorance.
No, 10% less is now been taken care of by another notification. Now, what has happened in terms with the Assam procurement rules 2000 so and so, whatever it may be, and governor have issued a notification that what happens is that if you have your bid less than 10% and less than 10 to 15%, then your security deposit increases. So that is being given. So that is when
14, I submitted on 16 to the executive engineer. Every time he said,
we give a direction.
yes,
That you kindly issue that the site verification certificate when they visit. Tomorrow at 10:30. No, tomorrow at 10:30, he is going to visit He has visited, no. Tomorrow you have, give it. Tomorrow you give him the certificate. Or we still have time today. You can give it today?
Well, there may. that's why I think
No, there's
all-
no, there cannot be any other reason for this. The site visit is only because later on you cannot. You see, the bidder shall obtain the year. The cost of visiting the site shall be the bidder's own response. Also acknowledges that the prior submission of the bid that he has also a successful and complete careful examination made an independent evaluation of the scope of the. You see, the reason is categorically mentioned. There's nothing else. He cannot do anything. Are you going to allow him to work out there today? No. He's only going to let, and in fact, this is an undertaking.
Madam, only provided he has visited the site. That is the main condition.
That statement.
Therefore, I'm saying, no, whether he has visited or not, it's okay. Tomorrow, ask your concerned engineer to be there. No, no. Your photograph is there.
Said not give. My idea is, my lord, there should be the competition should be restricted. They want to give the work to their own man. That's why they are doing all these things. These are the 4 applications, my lord, for the full work. Now he is to countersign it, that's all.
All same location.
Yes, my lord, Demoria.
So it will be different, well, 4 separate tenders. that
No, no, this page 22, these are 4 different works under the same district, my lord.
The location is Demoria only.
Yes. All Demoria.
Huh? Where is the site?
Page 22, my lord, page 22 of the petition. 47 to 50, these are the 4 works.
all
Construction of road from Uloni Kriki Homobai Committee, then construction road from NH to
Item number, serial number?
47 to 50.
57 to 50.
All of them.
No, these will be all different.
Yes. Different
Yes, madam.
works.
Maybe Demoria and the locations will be different, madam.
No, all will be different. Can you see?
All
You
the
have the
different-
location. No, you have mentioned the location as Demoria Kamrup Metro. You
Yes.
can't put that. The location has to be at this, from this area, wherever it is.
Yeah.
I think you should.
LSC. Legislative
Visit
Assembly.
the site of, so
constituency.
anyways, site they have gone there, but this is what he has said. This is the site where we visit certificate. Yes, go and sign it.
Anything, madam, if any other reason is there, I will proceed on Monday.
What
But
means?
we'll direct whatever is there.
No, no, Monday will not be possible.
No, no, I am not saying, madam. If any reason is there, madam, let it be posted on Monday.
No,
Today,
here he is only asking for, Mr. Gogoi, I'm not on anything else. I'm not on the tender condition. He is only asking on the site visit, that he has visited. In fact, later on, he cannot later on say that this site is this or that. So therefore, you have put a very good clause now that later on you cannot. And in fact, there are many cases, more particularly this is a normal thing. Now, this certificate has to be given by the concerned engineer. The concerned engineer has it been defined anywhere?
Page 60.
pay 62 complete.
Concerned executive engineer.
Yes. If your lordship will kindly come to page 29 for a moment. This letter I wrote on 16, my lord. To the executive engineer, these are my reference letters, my lord. Issuance of site visit certificate regarding. Now kindly see, my lord, in this regard, we are attaching here with geotech photographs of the same for favor of your kind disposal. I have
Wait.
visited.
Page 29.
Serial, yes, my lord. serial number
Issuance of site, yeah, with reference to the subject above in continuation of so and so, we are yet to receive the site visit certificate against the work as mentioned under so and so. However, our authorities have duly visited the site against the work order. In this regard, we are attaching herewith the geotech photographs of the same for favor of here. Photograph is given. Therefore, in view of the above, we are requested to kindly acknowledge the same, issue us the site visit certificates against the above mentioned work. Give it. Because tomorrow he will again file another case. That because of that I could not, or there is a delay and therefore I could not, which may be good for Mr. RM Deka, but not good for litigations. So let us finish up this four today itself. Nothing more. I'm not saying. Okay, left.
If for any other,
Well,
Anna.
considering this particular representation at page 31 and 29 and all, the executive engineer will take a decision and he will give the particular signature in this particular form. Provided he agrees that it is up to
provided I have given.
today, whatever representation has been submitted in this regard, in every repetition there is such a communication,
In fact, this is the same for all four works.
Four words.
Then
Considering this, issue it,
tomorrow.
Provided those geometric, those photographs are there. Yes. At least he will have to be, he will have to examine.
correct.
If it is there in the record, and this has been sent by post.
That is what, na. No, but it has been received, na. This has been received by the item delivered 18/7/2025. If you see page 29,
Yes.
the postal receipt and see the track consignment, it has been delivered.
Yes, 16/7.
18/7, it has been delivered. Hello, let me come back in 5 minutes.
Yes.
Heard Mr. Kane Chaudhary, the learned senior advocate, assisted by Mr. RM Deka, the learned counsel appearing on behalf of the petitioner in the batch of 4 writ petitions. I've also heard Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of the PWD. Pusto. The taking into account the issue involved in the batch of 4 writ petitions are similar, and there is a requirement of urgency, requirement that the matter requires there is a requirement of an urgent order, the instant writ petition is is taken up, the batch of writ petitions are taken up for disposal by this common order. Pusto. The chief engineer roads, PWRD, Chanmari, who is the respondent number 2 in the batch of writ petitions, had issued a detailed notice inviting tender dated 21/6/2025. Pusto. The petitioner herein is interested to bid against the works as specifically mentioned at serial number 47 to 50 of the said notice inviting tender dated 21/6/2025. The details as is mentioned in the said, the works in question, which are mentioned at serial number 47 to 50, are reproduced here in under page 22. Full stop. It is also seen from the said notice inviting tender that the bid submission closing date is on 28/7/2025 up to 2 p.m. Full stop. And that 2 p.m. And the technical bids would be open on the same date at 2:30 p.m. Full stop. The said notice inviting tender further refers to the bid document at serial number 5 of the note. Full stop. The said bid document contains various terms and conditions which are required to be fulfilled. Amongst them is clause 7.1 of the instruction to the bidders. Full stop. The said clause being relevant is reproduced hereunder. To put over the name. Page 26 of this, 7 side BGT. A perusal of the said above condition, above quoted condition, stipulates that the bidder at its own risk and responsibility is bound to visit and examine the site of works and its surroundings and obtain all information that may be necessary for preparing the bid and entering into a contract for construction of the work. Full stop. The bidder further shall obtain a mandatory site visit certificate with verification from the concerned engineer authenticating his visit to the site of works and submit the same along with the bid. Full stop. It is further seen from the very clause the reason why the site visit certificate is required. The reason being that the bidder, after a complete and careful examination, had made an independent evaluation of the scope of the project, specification and standards of the design, construction and maintenance, site local conditions, physical qualities of the ground, subsoil and geology, suitability and availability of the access routes to the site, and all informations Full stop. These have been, full stop. This acknowledgement of the bidder, this site verification certificate, upon being submitted by the bidder on the verification from the concerned engineer, is an acknowledgement by the bidder that he is aware of the various conditions stipulated, various conditions for which, on the basis of which he would submit his bid, and later on cannot take any excuse that he had not, that the site in question was not conducive for working, or the quantity, or the bid so submitted was inadequate. Full stop. The grievance of the petitioner herein, that the petitioner, though the representatives of the petitioner, though had visited the site on
14, 16. 14, 16, we visited.
on 16th,
Seven.
huh?
16/7/25.
All the sites. Had visited on 16/7/2025. No, on 14/7.
14th first made the request.
No, 14/7. This is the site visit certificate says, the copy which you gave it to me.
Yes. 14th and 16th also made.
On 14, no, all four are 14.
Okay.
Where is 16?
No, I also is correct, Malak. It is 14, 16 was again a request one.
On 14/7/2025. And thereupon requested the concerned engineer, who is the executive engineer PWRD, Dispur and Dimoria Territorial Road Division, the respondent number 3, to issue the site visit certificate in respect to the 4 contract works in question. However,
We made a representative chief engineer also page 30.
however, the respondent respondent number 3 have not issued, thus have not countersigned in the site visit certificate. And it is under such circumstances, full stop. The petitioner thereupon had submitted representations on 17/7/2025 as well as on 18/7/2025, on 16/7/2025 and 16/7/2025 to the respondent number 3, and on 27/2025 to the respondent number 2, but to no avail, for which the present batch of writ petitions have been filed. First, this court, having heard the learned counsels appearing on behalf of the petitioners, and also upon perusal of clause 7.1, is of the opinion that that when the petitioner duly acknowledges that he has visited and takes up the responsibility that he is satisfied and acknowledges that he had duly examined the site of works and its surroundings and have obtained all information that may be necessary for preparing the bid and entering into the contract for construction of works, comma, there should be no inhibitions on the part of the respondent number 3 to countersign the site visit certificates. This court further takes note of that if the petitioner is deprived on account of the respondent number 3 not countersigning the said certificate in spite of the petitioner's acknowledgement to the terms of clause 7.1 of the instruction to the bidders, it would amount to violating the rights of the petitioner under Article 14 of the Constitution, as well as 14 of the Constitution. Considering the above, comma, this court therefore disposes of the present batch of the petition with the direction to the respondent number 3 to countersign the site visit certificate so submitted by the petitioner. In respect to the 4 contracts as have been already submitted to the respondent number 3, so that the petitioner is in a position to file the same along with the bids in pursuance to the detailed notice inviting tender dated 21/6/2025. This court further grants the liberty to the petitioner herein to approach the respondent number 3.
Let him approach today itself. Just now I got the telephonic instruction that some registration certificate is necessary which the petitioner has not submitted. So
Registration is for another
that's
purpose.
what I'm saying, man, maybe some ground. That's why tomorrow, instead of having some dispute, today itself, let him approach the.
This court further grants liberty to the petitioner to approach the respondent number 3 by 4:30 p.m. today.
Yes.
4:30 p.m. today, along with copies of the site visit certificates, so that the signatures can be obtained from the respondent number 3. Full stop. The detailed order herein would be furnished by the petitioner by Monday to the respondent number 3, and in the meantime, comma, Mr. B. Gogoi, the learned standing counsel of the PWD, is directed to intimate the respondent number 3 that the petitioner, the representatives of the petitioner would be approaching the respondent number 3 by 4:30 p.m. today for the site verification certificate.
Person to the tender.
Yes.
Provided to the person to the tender. I'm not saying,
No, any document is for bid.
No, if required, maybe there is another clause where it is required, because I don't have the instruction. That's same saying,
Our reverse is not getting anything else on site verification.
I don't want, Mr. These are giving something, if I do put that document, I know what is the implication. So before parting with the record, this court, however, makes it clear that this court have not decided anything as regards the eligibility of the petitioner in respect to the notice inviting tender dated 21/5/2016. Ideal, huh? Ideal.
Regarding the operation of the private heart. No efficacy in private.
Your market was given for how much time? Market was given for how much time?
This is the private heart.
Then?
So for private heart, concerned by the so it's the
So it is your personal heart. Personal, then? Who is interfering?
so it is.
Oh, what is the police doing? Why are you disturbing him?
It is a second round of litigation, my lord.
Second, third. Let us make it the third round. You are selling cattle?
Yes.
Cattle for what? No person shall transport or offer or transport or offer for transport or cause to be transported any cattle from any place within the state of Assam to any other place in a district within the state which shares international border with any foreign country, the slaughter whereof is punishable under this act.
Person is within the district, not outside the.
This act, Lordship, district commissioner is the competent authority under this act. So already he has submitted one representation before the district commissioner, which is at page 19.
Private market in the name of an private. So your only allegation is the respond number 7 is disturbing. Don't disturb. He says that they are not going to disturb.
But we have, our instruction, we said that we have no role to play. So if he has any grievance, so let him approach before the district commissioner because he is the competent authority under this act.
No, I say that don't disturb unless there is a violation.
After the Cattle Act matter, enactment of some Cattle Act, he has to take one certificate registration from the deputy commissioner.
You have that?
That he has to do. That he has to obtain. And after the amendment of Assam Panchayat Act, being a private heart, he has to take NOC from the government, from the Panchayat.
So from the Panchayat Act, my lord, that that the defendant has already held that matter, that Panchayat has no role. So far, my lord, regarding my lord private.
No, my. Yes, in 2023, it is already.
Let's see the Panchayat Act 2023. You are the Panchayat Council, show me.
Actually, court number 17.
So far off, na? Court number 17. One may have to go cross the river Brahmaputra. Huh? Goodness.
For judgment, my lord, court master took my book. Another book is coming.
Are you saying that the court master of court number 17 is interfering with the cause of
No, my
justice?
lord.
Then something like that.
No.
Huh? You should have one book in each court. Panchayat is doing a lot of things. Yes, that day I got hold of one Panchayat matter. What is this wrong with your Panchayat matter? Issuing supply orders without fixing rates? How are you doing it?
My lord.
Whatever may be, is it ever heard of that you supply 1,000, you supply 2,000, you supply 3,000? No, this is done by the chief executive officer. And he is doing under the pad of the district commissioner. Yes,
Was wrong, but election was under the Assam state election only.
whatever may be, I think I will, in that matter, I'm going to make the finance a party. First of all, that day I was talking on. If you issue a supply order without fixing the rate, where is the consideration? Yes, you look into that. That lady appeared. What is her name? I forgot. Yes, look into that. I've asked them to file an affidavit by 6th.
I'm just.
Yes, please. Yes, now the thing is all this okay, we'll have it on some other date because your book is not available. Some other date doesn't means 2 minutes. I would have said this at 4:45, but not now. Okay. You have not filed affidavits. Heard Mr. A.K. Sharma, the learned counsel appearing on behalf of the petitioner. Gustav. Mr. S. Dutta, who appears on behalf of the Panchayat and Rural Development Department, and Mr. S.R. Borua appearing for the government of Assam. Mr. S.R. Borua appearing on behalf of the respondent number 7 submits that the respondent number 7 has no role to play in respect to the opening or closure of the market. And as such, the allegations so made as against the respondent number 7 is not at all sustainable. Full stop. Mr. S. Dutta, the learned standing counsel of the PNRD department submits that in terms with the Assam Cattle Preservation Amendment Act 2021, it is the requirement of law that if a private hut
From Deputy Commissioner.
Am I not aware what you, let me complete. Mr. S. Dutta, the learned counsel appearing on behalf of ER submits that even in respect to a private, that after coming into effect of the Assam Cattle Preservation Amendment Act 2021, even in respect to a private hut, there is a requirement of obtaining a permission from the district commissioner. The learned counsel further submitted that as per the Panchayat, Assam Panchayat Act 1994 as amended in the year 2023, the petitioner, in order to run the private hut, is also required to take a permission from the Panchayat if it falls within the Panchayat area. From which side? The government Panchayat?
The Panchayat and as well as from the
Private hut also?
yes, for private hut.
From the Gaon Panchayat and
the government in PNRD.
As well as the PNRD department.
Section 107.
He, however, submits, and in that regard refers to Section 107 of the Assam Panchayat Raj Act 1994. He, however, submits that he would like to place the materials on the next date, taking into account the above list this matter on 11th of August 2025. Interim order pastorally shall continue till then. The instructions so placed by Mr. S.R. Borua is kept on record and marked with the letter X. Next time, I hope you have the book. And next time, I also hope that when I'm dictating, don't disturb. Visa. Yes, what is this?
With regard to non-payment of contractual due, Justice will file the work order at page 16.
Yes, madam, why you are not paying?
For our lordship, that they have not completed as required in the NIT lordship. Lordship, may
You have filed an affidavit.
lordship.
Where is that?
Number 26, lordship.
Huh?
running page number 26, Lordship. That's our affidavit, Lordship.
26, yes. Where is that? Where is the statement?
Statement is from paragraph 8, Lordship, while local.
Which
Persons
paragraph
have
you are
already
referring
given a
to?
complaint,
There is
Lordship.
one paragraph 8 starts from page,
Lordship from.
which page? As per the report, the work was incomplete and hence payment could not be made. The same has also been informed to the petitioner for compliance. As of now, nothing has improved. You have not completed.
They have filed an affidavit now.
In reply that it is completed.
They have.
Okay.
That it is
Go
completed.
before the civil court.
Lordship will connect to the report
No.
page, but
Prove all these things before the trial court, civil court.
Lordship in page 23. the
No,
authority-
Mr. Counsel, I'm very strict. First of all, I don't like this contractual matters. Non-contract bill. One day when I catch hold of one limitation, I'll hold it. But as of now, it should get.
Only for page
No.
23 is the letter by the authorities. Page 23 is the letter by the authorities, wherein upon verification that they found that the work is complete.
Okay,
Page 23, Lord.
page
23.
23. Chalo.
The letter, 3822.
You do one thing. I'll have it next week. You produce the original, produce the petitioner in person. Next week, I'll be downstairs. I'll put what you call that particular thing, the witness box, and you cross it down. Okay? Oh, yes, because you have to prove this document. When they categorically say deny it on affidavit, they are denying it. I have no way out.
Also of the authorities, Lordship, upon verification. The authorities themselves directed for.
That is why we don't believe this executive engineer or the junior engineers. Nobody believes.
And the authorities themselves with the document for finalization of the final.
No case, no case.
In my.
Heard, Mr.
Yes,
Dismissed. The learned counsel appearing on behalf of the petitioner and Ms. M. Kotoke, the learned counsel appearing on behalf of the respondents. The petitioner herein has approached this court seeking a writ in the nature of mandamus, directing the respondent authorities to prepare the final bill in relation to the work allotted to the petitioner by work order number DVT-186/SOPD-G/2020-21/89 dated 16/9/2020. And further, pay interest on the said final bill from the date of completion of the work, that is 15/3/2021. Full stop. The learned counsel appearing on behalf of the full stop. It is seen that pursuant to the filing of the instant writ petition, an affidavit has been filed by the respondent number by the in charge director of the Animal Husbandry and Veterinary Department, Assam, who have been implemented as the respondent number 3, wherein at paragraph number 8, it has been categorically mentioned that as per the reports so available with the said respondents, the work was not completed by the petitioner and hence payment could not be made to the petitioner. And this aspect have been also duly informed to the petitioner. The learned counsel appearing on behalf of the petitioner submitted that a perusal of annexure A5, which dated 3/8/2022, would show that both the assistant executive engineer PWD as well as the junior engineer PWD have given a certification to that effect that the work is completed as per the original drawing, and further as per the visual inspection, the quality of the work is found to be fully satisfactory. This court takes note of that these are questions which falls within the disputed arena as to whether the petitioner herein is entitled to the amount as claimed in the petition and whether and further as to whether the petitioner had actually completed the work in question. Considering case, considering the above, this court is therefore not inclined to exercise its jurisdiction. Be it as it may, this court grants the liberty to the petitioner to approach the civil court if so agreed, if so advised, and the period from 28 to 2023 till date be excluded while computing the period of limitation. Everything is understood. Mr. Counsel, I'm understanding that, but the question is disputed. Very difficult. Yes, Mr. Pathak, non-payment of dues, what has happened? Entitled?
Affidavit amount is under process and which we release.
6 months.
That's it.
Dispose enclosed as the Ms. D. Bora during the course of the hearing had submitted a communication issued by the Assistant Director of Agriculture Information, wherein it has been stated that, wherein it has been admitted that the wherein it has been stated that the financial dues as claimed by the petitioner amounting to rupees 65 lakhs 1,800 against the bills raised by the social media management and digital promotion of the Director of Agriculture Assam is under active consideration of the department. That it has been also mentioned that the department has already initiated the process for release of the payment against these dues at the shortest possible time. Pusto. The said communication is kept on record and marked with the letter X. Verification in view of the admission that the said amount is payable to the pay the said amount within 6 months from the date a certified copy is served upon whom? Certified copy? Director? Industries? Animal husbandry. Respond number?
Number 2.
I will put his name in golden letters. Mr. B. Chakraborty, the learned standing counsel. He has not appeared last time also the other side.
Last time also. Lordship, matter may be closed because they release.
We have got the written communication. Mr. B. Chakraborty, the learned counsel submits that the petitioner have already got the relief.
Now, take note.
Have already got relief, and in that regard, have placed before this court the written communication which is kept on record, collectively kept on record, and marked with the letter X. So for taking it therefore appears that the petitioner have not appeared, the counsel for the petitioner is not represented for the last 2 occasions. In that view of the matter, nothing remains in the instant proceeding for which the petition stands closed. None appears for the petitioner as well as the respondent when the matter is for ends of justice here. So you are appearing both. What is this? Contractual bills. Admitting, not admitting. You are 2 lakhs. Same 2 lakhs.
5812/20.
Similar order. 5140. Ito order did you want? Do you have that order?
I have the number 5812/2024.
The order type did you?
Amount is different. Here 10 lakhs. In that case,
This amount is 10 lakhs.
Well.
And last, in that case, how much?
5 lakhs.
How much time did I give?
First installment was 6 lakhs was released.
No, how much time did I give?
3 months.
3. Okay, this is 10 lakhs. 6 months. Contractual 89,000. Then you should pay.
Yes, you should claim for department and. it's not- but my- Lordship, I want to find- Yes.
Security money has left me. Okay, when was he entitled to? 3 years is when? '22, and he has filed a petition in 2024. So we will give the benefit that as the petitioner was filing the petition, out here was bona fidely believing. So 1 year remains. So she can very well do it. 7 days. Then you, on one hand, you are saying that she has not applied within 3 years, so you are not going to give. Now, when I say that 1 month, 1 year can be taken from here because she has filed within 2 years, then you are saying now bringing the finance department somewhere. Don't come up with all these things. For what? You file affidavit, I impose interest at 18%. 89,000. Yeah, water resource department. Water resource, na? Nice, that's the office. The Art Deco, the Learned Council appearing on behalf of the petitioner seeks for an accommodation for filing the affidavit in opposition. First, this matter again on 11th of August 2025. In the meantime, the affidavit in opposition be filed by 8th of August 2025. Same order, 11. Yes, what is this?
Your Lordship, this matter pertains to denial of arms license, Your Lordship. Under the respondent number,
Rejecting the petitioner's prayer for grant of arm license. What do you mean by arm license?
Lordship, he is a political activist and a businessman.
Huh?
Political activist and a businessman.
My goodness, you have not filed affidavit, you have filed.
Lordship, from the police authority, we have filed our, from the police
You
authority.
are opposing it.
Yes, because as per the police authority affidavit, that it was not recommended as there was no specific threat to him. And another case is pending against him that has been started. Your Lordship, I want to file a reply to this.
Sai Hussain, the Learned Council submits that he would like to file a reply to the affidavit in opposition filed by respondent number 4. First of, taking into account that the affidavit in opposition by the respondent number 4 was filed on 29/1/2025. And then last line, files an affidavit. First of, list the matter after 4 weeks.
On behalf of the district commission. On behalf of the district commission, I will file my affidavit.
I normally fix a date in all matters. I'm not fix a date in, meaning thereby that I am not inclined to grant him the relief. Yes. Oh, contractual, AK Gogoi, where is he? Yes. What is your instruction, Mr.
Lordship, we have filed our affidavit, Lordship.
You have not filed affidavit?
No, we have filed, Lordship.
This
So,
one,
yeah.
AK Gogoi, this one, Bobby Core,
Yes.
that is not on record. What is your stand?
They have admitted your lordship, but
Admitted one part, Lordship, not the full part. We have admitted only 7,25,516.
It has been submitted by Mr. S.R. Borua, the Learned Council, that an affidavit has been filed by the respondents on
Filed on 22/5/25.
22/5/2025. The said affidavit is not on record, so the registry shall list this matter again on 13th of August 2025, along with the said affidavit. Yes,
There is an instruction from executive engineer admitting the amount from executive engineer. But best, my lord, would be that if a direction can be given to chief engineer to verify and payment. This can be kept on record, my lord, the executive engineer. Okay.
I will direct the respondents to verify.
Yes, respondent.
To গোটেইখিনি লিখি দিব এইখিনি আগৰ এইখিনিটো লিখিব Mr. I Botaku Dolani Council appearing on behalf of the PNRD department, PHE department submits an instruction issued by the executive engineer, PHE, to the effect that certain payments are due to the petitioner in respect to the work which have been duly completed by the petitioner. It has also been mentioned that after receiving the budget, the said payment would be made. The said instruction is kept on record and marked with the letter X. Taking into account the above, shall make a verification as to how much payment, make a verification as regards the payment, as regards the entitlement of the petitioner, and upon verification, if it is found that the petitioner is entitled to the amount so claimed, or any other amount, the same be paid within a period of 6 months from the date a certified copy is served upon the chief engineer. Chief engineer is the party here. What is this weakness? No, weaker man. Fishery Cooperative Society. What is this type of name? It looks like somewhere we are in England. Weaker man. Oh, did you stay? No affidavit file.
I have received instruction also. In a period of 7 days, I will file it.
File it. Interim order is going on.
Otherwise,
I don't pass. I mean, interim order, if it is there, it's very bad.
for going to the
Mr. K. Gogoi appearing on behalf of the Railway Authority Railway submits that within a week's time, the affidavit would be filed. He also says, Post list this matter again on 28/2025, the affidavit be filed, affidavit in opposition be filed by the respondents on or before 13th of on or before 12th of August 2025, the petitioner, if so agreed, if so advised, would be at liberty to file any reply. The interim order passed earlier shall continue till the next day. File it, interim order.
first was as per instruction, as per number 5 is not a supply. That clause is not fulfilled.
Huh?
I have received the instruction, Lordship. The particular terms and conditions which was to be followed, Lordship, that was not followed. I will place it by way of affidavit.
He is not qualified. So we have to allow his petition.
Lordship, just filing the affidavit, Lordship. We have also not issued the order also, Lord. No, obligation.
Now comes the contempt jurisdiction. Unpaid. Oh. Now you're paid. Oh, this amount. I remember we have asked this person to appear, nah? Isn't it, Mr. Pigu? Got the money?
My first, that the 1 crore 52 lakhs minus deduct from.
Ah?
They deduct 1 crore 52 lakhs minus. due to the, my lord,
Have you got the money or not? Now you want more money. Why you have not filed a reference? I can't help you more than that. It was a very difficult case. I bifurcated, somehow gave these directions out here. This is how it happened. Otherwise, you would have never got this money. Very difficult. I treated this contempt petition as if like a writ. Isn't it? No, we close it. Liberty given to, you have to seek a reference. If you want more money, you seek a reference. It has been submitted by Mr. G. Pegu, the Land Council, appearing on behalf of the District Commissioner Demaji, that the amount of rupees 1 crore 50,
1 crore
1 crore 97 lakhs.
97 lakh 6608.
How much did you pay to the petitioner? How much?
97 lakh 6608.
Have already been paid to the petitioner in terms with the judgment and order dated 15/5/2023. Petitioners, na? Petitioners. Full stop. Taking into account, therefore, taking into account the above, comma, this court treats the said payment to be in compliance with the order dated 15/5/2023, passed in WPC number 4825/2018, and accordingly drops the present contempt proceedings. Full stop. It is, however, observed, now before parting with the record, this court, however, observed that the satisfaction that is recorded herein above, that the order dated 15/5/2023, passed in WPC number 4825/2018, shall not preclude the petitioners in WPC number 4825/2018 to seek a reference if otherwise, seek reference for on account of inadequacy of compensation if so advised, if otherwise permissible under law. I gave you a something, do something. Yes.
Lordship has directed them to pay the principal amount.
These must be those PHE, na?
Lordship,
Arbitration,
one of the questions-
MSME. Without seeing only, I have come to see.
Lordship,
Four contempt 3 weeks.
Lordship, now, the question, Lordship, before your Lordship is the entitlement to interest under the MSME Act.
Huh?
Entitlement to interest as per the MSME Act. On the last occasion, Lordship had asked them to pay the principal. They paid the principal. Now the question of interest. that's
Oh,
what the
that they, this I will take it up, all these things. The contempt has to be dropped.
What the and the matters can be solved.
Contempt, we drop it. Stop. Taking into account that the,
No, the contempt. Lordship, not
what?
this Contempt earlier order.
That order no longer survives. Does the contempt survive now?
That order also survived, but they had not given the as per the
What order is that?
principal as per interest. They took a portion of their admitted interest, not the entire. The principal
What is
had
this contempt?
the order, earlier
order?
order passed. That's earlier on.
Look into the said representation for making payment of outstanding dues with interest. There is no direction for payment of interest.
Those cases.
Oh, contempt does not survive. Where? Where is the speaking order required?
Because they were supposed to
There's
dispose
no
of the-
direction, preferably
No,
within
they're
3 months from the date of receiving the order of the court or receiving the copy of the order to be submitted by the petitioner. Order
Yes.
record. Chalo, one day we'll decide, because I am not inclined to gun the interest here. That is the question which has to be taken before the facilitation area. One, secondly, these are awards. Go under 36. I am not going to touch on interest. When do you want the dismissal of those apart from the principal? I am not inclined. That is why I asked them to pay the principal. That I'm looking it. That is why I'll pass an order later on. That interest go under 36. It's an award. Yes, it's an MSCB award. No, I'm not saying that. I'm saying about these are awards passed by the MSP tribunals. Arbitration. No, these are award. Are these not awards? What are those?
The engineer had calculated, the chief engineer, and verified and admitted in the writ petition that this is the interest which we have principal and this is the interest. On their admission, we came up before this honorable court. Now, in the various affidavits which were filed in this proceeding, the chief engineer has admitted that this is what is due to them. They admitted up to 2019. Let it be up to 2019. We have to pay, but because of paucity of fund, we cannot pay. Now what has happened, the new chief engineer has come. He said, we don't even know whether they are MSCB. So we do not know. How could they have given us the orders if we were not MSCB? The policy of the government, both under the Assam special preferential stores purchase, thereafter the procurement policy, everything specifically provides that for these items, the government procurement will only be from MSCB. And we were registered MSCB. We have given a chart that during this supply, this order, we had this MSCB certificate.
But if I remember, my order which I passed was in respect to some award passed by the tribunal, MSCB. These I didn't pass any orders. No, these are nothing to do. No, in these matters, I have not touched. Oh, therefore, that is a different matter.
This has to be claimed under.
Alternative remedy.
That is not correct.
Alternative remedy, no?
Not the position of
That
law.
alternative remedy.
How much I'll put it in your mouth that this is argue that.
But that
Okay. Alternative remedy. We'll consider it on the next date. Well, some kinder judge should take it up.
My lord will be able.
No, I'm not a kinder judge for the petitioner in this type of matter.
but we cannot. So I'm sure not
Okay.
how good case they are.
Okay. So,
Also the perjury committed by the engineer, chief engineer.
so when can we have it? We finish it. Means I would have, because I may not be taking this bench for long.
Anytime.
When? You?
Fifth of August.
Fifth?
That's a Tuesday.
List these matters on 5th of August on which date an attempt shall be made to dispose of the petition. So, matters would be listed would be taken up at 2 p.m. Service? Complete?
I can for 56 months.
In item number 46, petitioners have received the amount matter, although they are not satisfied matter. So it may be closed with liberty matter to approach appropriate from by appropriate proceeding, because they are not,
Now 46, 47.
they are not satisfied with.
No, I cannot give you that liberty. Whether you are, you see, what is the direction given? Let us see that. What is the direction given?
Page 50.
And page,
50, ma'am.
land acquisition.
Land acquisition.
The problem. I dispose of the by directing the yard take immediate step for preparing a correct and authenticated assessment of the amount of compensation that is required to be paid to the petitioners, and thereafter send the report to the chief engineer with the report so and so, so and so. On receipt of the demand, the yard will initiate necessary for releasing them within a period of 3 months. So this is being done, and you have received the amount. Now the question is that you are not satisfied with that amount. Mr. UK Das, the learned counsel appearing on behalf of the petitioner submits economic liquidity 454. 454, submits that in the pursuant to the directions passed by this court dated 27/2/2018 in WPC number
2474 of 2004.
2411/2012, isn't it?
No, madam, it is 2474.
Huh?
It is 24.
Where?
Page 1, madam. Page 1, madam. That was common note, common note.
2474,
74.
page, where do I get the detail? 2474/2012. Submits that in terms with the directions passed by this court dated so and so in WPC number 2474/2012. The respondents have made the assessment and made payment to the petitioner. So, taking into account the above, he however submits that the petitioner is not satisfied with the amount so awarded. Taking into account the said submission, nothing further remains in the instant contempt proceedings for which the contempt proceedings stands dropped. It is observed that the dropping of the instant contempt proceedings shall not preclude the petitioner when did they make the assessment?
It was done in two phase, madam. It was done in two phase, madam.
When?
Prior to filing of the repetition.
When? Has dropped. Very good.
In item number 47, madam, they have not received any amount.
47, no, not payment.
Madam.
Why they have not paid?
Yeah,
Who are these?
We have taken, justice service taken newly implemented, madam, response number 12, madam.
Who is he?
He is the chief engineer, madam, PWD National.
Mr. Naik, please help this court. What is his name?
Subimol Kuli, madam.
Huh?
Subimol Kuli.
Subimol Kuli,
Madam.
Chief Engineer, NH Sanmari.
Madam.
It has been served upon whom?
Not represented. Notice was issued on 10/5/2022.
You have served upon whom?
My lord, response number 12, my
Whose signature is this in the dusty?
official, my lord, received.
Whose signature it is? No, this cannot be a service. It's a contempt. Office cannot receive it.
Moreover, lordship, he is not the person holding the post.
No, because this is a contempt. He has to receive it. And if you
He said no, that he was not allowed to enter into the.
ask some of your junior to go or your clerk to go, this person need not go out there. So this court have duly taken note of the dusty service, affidavit of dusty so served, so filed, as well as the return memo. From the state, it appears that the dusty service has not been effected personally upon the respondent number 12. Rather, it has been served upon some official of the Office of the Chief Engineer, Public Works Department, NH Chanmari. So considering the above command, this court is of opinion that the said service cannot be said to be a proper service by way of dusty. And as such, the affidavit of service is not accepted. So the petitioner hearing is directed to take fresh steps by way of dusty upon the newly pleaded respond number 12.
My learned friend submitted, he is not present. He is not the present civil engineer as per the.
Not accepted, full stop. Mr. Ukedas, the legal counsel submits that he has also received some instructions that the respondent number 12 is no longer the present chief engineer. So he'll obtain instructions and place, obtain instruction, list this matter again on 18th of August 2020. What is this?
My lord, I was the settlement holder of a Kathikabadi market, page 28, kindly come on, page 28. Kathikabadi market, bid amount was 16,60,000. It was 2010, and I have cleared the dues, entire dues. Term was over, they have returned my security deposit, and they said that nothing is due from me. Now, my lord, after 7 years, they have served with this notice. Oh, there was a mistake on our part that you have not registered your agreement. So you pay the court fees of 2,60,000 rupees, registration fee 93,000 and stamp duty 93,000 after 7 years. In a similar case was come up before the Honorable High Court, my lord. Exactly same thing. My lord, Honorable High Court has decided this, my lord.
It is to be registered.
Till now, it has not been, yes, not even utilized.
Huh?
Till today also it is not in practice, but in a paper it is there. And my lord, now after 7 years, how can they ask me to pay? It's a time
I
part.
don't think they have to. No, this is different. You don't require to be here mentioning it, the register is not because it's a government grant. When it's a government grant, as per the Registration Act, you are not registered unless you amend your Registration Act. You see, Registration Act makes it very clear, if you look into it, that when it relates to government thing, you don't require to be registered. And therefore, otherwise tomorrow, if the government is giving any settlement, you have to register it. A contract is being given.
Because these are the autonomous body, my lord. Panchayat, it's a PRI.
Panchayat is not autonomous. But
Exactly what-
Panchayat is not this is not, cannot be autonomous. See the Registration Act. There's no interim order. It's an important issue. You are not filing your affidavit, so
My lord,
we'll be taking that you have nothing to say.
because instruction received.
It has been submitted by Mr. and there is one order by Justice Manish Chaudhary.
But my submission is on law point, my lord.
It is,
That- some Panchayat finance rules, my lord.
my lord justice. Michael, my lord.
Rule 11(2) and 16, my lord. But after 6 years, that I'll not submit anything, my
That is the case.
But this has gone on the question of limitation. The same time, can't help it. এখন এইটো মতে dispose কৰিব, এইবোৰ ফোন বদলাই ল'ব, because dispose. You have already appeared, but the issue is very interesting.
Yes.
In view of section 81, I think it's 81 of the registration act. Have a look at it. Yes, apply.
Lordship has received the instructions that budget, for want of budget, it could not be paid, but in the 25, 26, it will be paid.
Huh?
Because due to financial process, it will be paid by, the payment will be in concern with this, financial year 25, 26, it will be paid. This is the.
Pay with interest? 18%? Non-compliance? How much amount?
That's 38,110.
When are you going to pay?
As soon as the, as soon as the.
No, there's while giving contract, you did not say anything.
Resource department.
Water resource, the government is one government. You have different governments. Only one government. That is not the elected members. One government only. Then we can't help it. I would have understood that the central government has not paid. I would have understood the state of West Bengal have not paid. But state of Assam dues, everybody is when? It has been submitted by Mr. S.S. Roy that the petitioner's entitlement is delayed. A petitioner have not been, the respondents are not in a position to pay at present, taking into account the financial exigency, financial exigency. Unless are six for some time. Who are these people? Okay. 9 lakhs.
9 lakhs, 38,100.
Okay. District Commissioner has an office. Put it on sale. Sell that office. It is observed that the financial when there is a direction passed by this court to make verification, it is observed that as there is already a direction, passed by this court, the question of non-payment and direction passed by this court, and that too within a stipulated period, and that order having not been challenged, the respondents is not in a position to state that the state does not have the money to make the payment. Full stop. List this matter again on 22nd of August 2025. On which date? The respondent shall provide the this is in which scheme? Okay, shall provide the head of account of the SDRF state head of account. This is under this contract, na? Of the SDRF. So that if no payment is made, comma, this court can pass appropriate orders for attaching of the same.
This case, Lordship, similar Lordship, today a telephonic instruction received that the budget has been received yesterday.
It has been submitted by Mr. S.S. Roy, the learned counsels, appearing on behalf of the respondent, that the budget have already been received and the payment would be made within a short time. Considering the above, list this matter on 22nd of August 2025 for an update. Niki, Niki, 51 to 56. Yes, what is this? Did I pass any order? My review.
Ministry of Jal Shakti has not been implicated as a party respondent. And in similar, or water resource department has filed 125 review and 125 review.
Who?
Water resource department for implementing water, Ministry of Jal Shakti. This is the order which Honorable Justice.
Oh, this one, na? Now, tell me, here in these matters, without the registry of Ministry of Jal Shakti being party, these directions were passed. Now the problem which you are facing is there are many directions passed and your contempts are being filed. Now, how do you take care of, kindly come to page 169 of the petition. How do you take care of number 2? This is what I also thought. The same order has been passed by Justice Shyam. The question has been reviewed, has been rejected because it is for the petitioner, because this is not an implementable order unless you unless the minister, you can very well. The only thing is, have you within 60 days provided it to the Ministry of Jal Shakti? If you have done it, it becomes it. We dispose of all these things by this order. This court, so the present review application has been filed challenging the order dated. Challenging the common order dated 27/9/2022 passed in WPC number. Number 1889/2022. Full stop. Whereby the learned coordinate bench of this court had, after hearing the said writ petition along with a batch of connected writ petitions, passed the following order. A 1, 2, 3 কৈ গ'লি। এই বাকিখিনি সব এয়া লিখি পেলাই এখন এইটো অৰ্ডাৰ ফলো কৰি দিম। ঠিক আছে? আগৰখিনি মই কৈ দিম আৰু এইখিনি য'ত হ'ল এই ৰিট পিটিশ্যনৰ নম্বৰ একো নাই দিয়া বাকিখিনি সব একেই। ঠিক আছে? এই অৰ্ডাৰটো বাকিখিনি কপি পেষ্ট কৰি দিম গোটেইখিনি। ঠিক আছে? All these 5 will same. So beleg order hobo de. এই গোটেই পাস এইগিলা dispose 51 to 56 disposed. What is this? Then? What stay? Where is the stay?
Your Lordship will find the stay order.
You are the petitioner.
I am the applicant, my lord. I am the private respondent. I have filed.
You are the petitioner.
Yes.
You are normally this one government.
Yes.
Oil. The award list in respect to serial number 5 and 6, that is the repairing of bazaar at so and so, which has been awarded to the respondent number 6, shall remain so till the next returnable date. Has it been extended?
Yes, my lord.
Where? When was it extended? Oh, list the matter after 4 weeks. It has not been extended till the next returnable date. Matter has come up. Has it been extended? Oh, yes, they have extended it. Hello. What do you want?
My lord, we have filed an IA praying for vacation of the stay order, my lord, because my contention is that vacation stay order has been.
Have you filed affidavit?
No, my lord, I have filed the application praying for vacation, my lord. Because from the record, my lord, I can show that, my lord.
Oh, Mr. Gupta, that day, one non-payment of dues, I have again fixed it next week. That order I said I'll dispose it of, I did not. Because there is a spec, while seeing the file, when it went on, seeing the file, I found out that he filed earlier writ petition. That writ petition was withdrawn. That withdrawing order is not there. And then again he filed, whereas res judicata would not come in. And in fact, there was a case, a suit having been filed by FCI against them, claiming some amount. So therefore, I have fixed the matter again next week.
So in this case, municipal board has not filed their approval. They are the main party, Lordship, they have not filed.
Record was called for, sir. Record was called. Next we will file it. My lord, on last occasion, records were called for, my lord. And my lord, IA, my lord, stay order, vacation petition, that may be treated as an affidavit on my part. Issue is very simple, my lord, only a small issue, my lord. After floating of the tender, my lord, there were, because there, in the tender, it was stipulated that the tenderer can quote a rate of 10% variation, my lord, 10% less or 10% more. So, my lord, when 2 or more tenderers quote the same rate, 10% less, my lord, in that case, what to be done? So, accordingly, the board took a decision, my lord. And it is
alleged in the writ petition that, my lord, that decision was taken by the chairman. But from the records, your lordship will find that that was not taken by the chairman, my lord. It was taken by a board, my lord, a committee, my lord, where the chairman was not a party, my lord. And the private respondent, they have alleged that private respondent is the son-in-law of the chairman. So chairman took a decision to favor the private respondent, my lord, so that he can be awarded the contract.
You are the son-in-law?
Yes, my lord, that is admitted. Son-in-law, but that doesn't diverse me from participating in the tender process, my lord. Because, my lord, if your lordship takes up my IA, my lord, only one page I will show, my lord.
And he has filed affidavit against the I.
Yes, sir, I have filed.
So his allegation are twofold, as I could see.
Yes.
First is both are L1.
Yes, my lord.
Then there is a methodology. What is the methodology?
No methodology. They have changed the methodology. As the petitioner is the highest, petitioner got the highest mark, then the private. That's why lordship, if peruse the 11, page 11, that was changed, and that was put up before the chairman who has accepted the that
The
changing of the
methodology. After the decision or prior to that?
prior to this.
Prior to that, then chairman, what is wrong?
Lordship, that decision.
No,
has
what
been-
is the methodology taken?
No methodology.
Methodology was that, my lord, when there will be two L1, my lord. Then, my lord, certain marks will be granted in respect of the, my lord, financial turnover and the scope of work. My
They
lord,
mentioned in the contract.
no, my lord, in the contract it was not mentioned, my lord. Because that methodology was subsequently adopted by the committee, my lord. And committee consisted of, my lord, deputy director, then the representative, all the technical departments like public health engineering, then, my lord, public works department, and medical municipal administration department, all the representative were there. They took a methodology. Then when there will be more than one L1, my lord, what to be done? They adopted the methodology, and it was put up to chairman, my lord. So chairman was not the person who took up or adopted this methodology. And, my lord, tender process, normally a tender process can be interfered by your lordship when there is a mala fide, my lord. Mala fide can be shown. In this petition, my lord, there is no mala fide. The chairman has not been made as a party respondent, my lord. Mala fide has not been alleged against the chairman, my lord. Only the statement that chairman has adopted this methodology to favor the private respondent. But neither he has been made a party nor mala fide, my lord. Because in the case of Roanoke International, it has been clearly stipulated. Only when mala fide is there, mala fide can be shown, my lord. Then your lordship may interfere, my lord. And
What about malice in law?
malice against whom, my lord? If your lordship peruses the
There is a
petition.
malice in fact and malice in law. If it is a malice in law,
Yes, my lord, that also can be seen, my lord. But the thing is that, my lord, it is not only in the case of petitioner. There were various work orders. Because, my lord, when suppose a tender amount has been fixed 10 lakh, so 10% variation plus minus. Normally, the tenderers quote, my lord, minus 10%. Obviously, there will be more than one L1, my lord. In that case, what to be done, my
so
lord?
if it is obviously more than L1, then obviously they should have put a clause. They know it.
My lord, the decision of
Anyway,
the tender authority,
everything boils upon him.
your lordship may peruse the records, my lord.
No, ask him to file them. Mr. K. Gupta, the learned counsel appearing on behalf of Hing Municipal Board. 345. Submits that a week's time may be granted so that the affidavit in limits that the application for stay vacating be taken up. Taking into account the above, list this matter on 28/2025. the affidavit, no, 13/8, 13/8/2025. The affidavit we filed by the respondent number 345 on or before 6th of August 2025. The petitioner, if so advised, would be at liberty to file the reply on or before the next date. Full-stop. It has also been submitted by Mr. BK, her name is BP Bora, the learned counsel, that he would, that the stay vacating application be treated as the affidavit in opposition. Why are you not filing it?
Because my lord, that is the main.
You're not getting the point.
Yes,
There's
my
no.
lord. Yeah, I will file. In the meantime, I will file that. Yes.
Mr.
Before
BP, the learned counsel appearing on behalf of the respondent number 6, huh?
Yes, my lord. Six.
The 6 or 7?
Six, my lord.
Six
Respond number
submits that by 4th of August, the said respondent would also, by 6th of August, the said respondent also would file the affidavit in opposition. To stop. List the matter in the stay vacating column, in under the caption stay vacating column, as directed upon.
Deeply obliged.
Interim order first earlier shall continue till the next day.
Deeply obliged.